Good afternoon, everyone. Ooh. Good afternoon. If people could take your seats. Good afternoon, everyone, and welcome to the second Pennsylvania Guardianship Justice Summit. My name is Lois Murphy. I'm a judge of the Court of Common Pleas in Montgomery County. I'm really pleased to welcome you here today, along with my colleague and co-chair of the Advisory Council on Elder Justice, Sheila Wood Skipper, who's from the Court of Common Pleas in Philadelphia County, an administrative judge of the Orphans Court Division. It is a privilege and a pleasure to be with all of you today to commence this second Pennsylvania Guardianship Justice Summit. I do want to let you know that we will be live streaming today's program, and all of the other programs tomorrow and Friday will be videotaped. I don't know if we say videotaped anymore. Will be taped, and you will be recorded, and you'll have access to them, and we'll let you know how to access them after the summit. So if you're concerned that you don't want to miss one of the other programs that conflicts with the one you're attending, you will have an opportunity to view it later. I want to welcome all of you here. Many of you have been involved in this work for many years. Many of you were able to attend the first Pennsylvania Guardianship Summit in September of 2023. I particularly want to welcome some of our special and distinguished guests. The Secretary of Aging of Pennsylvania, Jason Kavulich, is here. I don't know if State Senator Maria Collette is here today, but she will be here. There she is in the back. Others who will be attending, maybe today, certainly tomorrow, include Chief Justice Deborah Todd, who will be with us tomorrow, Andrea Tuominen, the Court Administrator of Pennsylvania. I did see that Judge Patrick Woodward, the former Chief Judge of the Appellate Court of Maryland, is with us today and will be speaking, and Judge Evelyn Patsos of Massachusetts will be joining us. Erica Costello, the Director of the ABA Commission for Law and Aging, will also be with us if she's not already today. And we have Pennsylvania judges participating, too numerous to mention. We come together to share our experiences and our efforts to reform and improve guardianship practices and proceedings in Pennsylvania courts. We welcome all of the judges, the lawyers, the guardians, the protective services workers, the legislators, members of the Shapiro administration, and many others who are invested in assuring that older adults and other adults subject to guardianship proceedings receive due process in Pennsylvania.
It is also my honor and pleasure to welcome you all to this second Guardianship Summit. Thank you for being here today and for your commitment to an issue that affects the lives of so many of our most vulnerable members of society. My involvement in this transformation has not been as long as others, such as Judge Murphy, as I spent my first 21 years on the bench on the criminal side. And there, I occasionally was introduced to the awareness of elder abuse and neglect involving seniors and the aging population as victims and defendants, where it appeared that there were not appropriate resources available. But my interest was really elevated to a personal level when my mother developed Alzheimer's dementia. But our family was prepared, unlike so many other families, because we had the right tools. Both my sister and my niece are nurses. We had a power of attorney. We had a care plan. We had family members who were engaged and involved. So guardianship was never a consideration for us. But I watched as I transitioned into orphans court as families who were not prepared struggled to deal with the harsh realities of navigating health care, finances, safety, forcing families to seek guardianships when maybe they weren't even necessary. And in rural areas like Philadelphia, when maybe we were more challenged in terms of resources, and family support may be a little bit more limited, and alternatives to guardianships truly are sometimes not available. And I have watched the pain and suffering of family members who want to do the right thing, but who are challenged by other family members with ulterior motives, lack of understanding, and receiving conflicting and erroneous information as they try to properly protect the best interests of their loved ones. This is where the work and reform done by the task force and the Advisory Council of Elder Justice has really become transformational. This journey began more than 10 years ago, and it has brought us to this point where we can take stock of the profound changes and improvements that have truly transformed the court's approach to guardianship cases in Pennsylvania. Guardianship was created with good intentions to protect individuals who are deemed unable to make decisions for themselves due to age, disability, or cognitive decline. But the system was in urgent need of reform. So in 2013, the Pennsylvania Supreme Court convened an elderly law task force to review practices and procedures in the courts to improve due process and access to justice, with two areas of particular focus. That included elder abuse and exploitation and guardianship proceedings. Fortunately for all of us, Chief Justice Deborah Todd was asked to serve as the chair of the Elder Law Task Force. And in 2015, the Supreme Court asked our Chief Justice Todd to serve as the liaison justice for the work of the Advisory Council on Elder Justice. Since 2015, Chief Justice Todd's leadership and support, with her leadership and support, we have tackled many significant projects with an eye towards improving the quality of justice in Pennsylvania courts for older Pennsylvanians.
We've accomplished a great deal over the past 10 years, and so many of you have had a hand in making this work possible and successful. We're deeply grateful to Chief Justice Deborah Todd and to all of the many hardworking and insightful members of the Advisory Council on Elder Justice over the past 10 years, particularly to Judge Paula Ott, the first chair of the Advisory Council on Elder Justice, to two former court administrators who've been committed to this work, Zig Pines and Jeff Moulton, as well as the current court administrator, Andrea Tuomanen. We've been incredibly fortunate to have extraordinary leadership at the Office of Elder Justice in the courts for 10 years, first led by Kirsten Hamill and now by Amy Whitworth, who's here with us today, and aided by a truly remarkable staff who deserve tremendous credit for bringing this summit together. And I know a lot of you have interacted with the staff in preparation for the summit. We've benefited from significant support from Governor Josh Shapiro, from current and prior attorneys general and secretaries of aging and human services, including the current secretary of aging, whom I mentioned, who's here with us today, and the secretary of human services, Valerie R. Cush. We've also shared ideas and a passion for improving the lives of Pennsylvanians with numerous Pennsylvania legislators, including State Senator Maria Collette, who's here with us today and whom I mentioned, and State Senators Art Haywood and Lisa Baker, as well as members of the House, including the current Judiciary Chair, Tim Briggs. With Chief Justice Todd's leadership, we have collaborated with national leaders and leaders from other states and leading advocates for elder justice from across Pennsylvania. Some highlights of our work undertaken by the Advisory Council on Elder Justice and the Office of Elder Justice in the Courts include the design and launching of the Guardianship Tracking System, which launched in 2018 and which assists us both in monitoring individual guardianship cases and in providing data to understand how guardianship works in Pennsylvania and how our practices can be improved. Publication of an elder abuse bench book and a guardianship bench book as a resource for judges, numerous speaking engagements and educational programs for judges, lawyers, medical providers, and the public.
So we are gathered here for these next couple of days, not only to discuss what might be broken, but more importantly, to build consensus on how we fix it. Too often, we've seen cases where guardianship leads to loss of autonomy and even basic rights. Some even lose control over their finances, where they live, their medical care, and in some jurisdictions, even their ability to vote, with little recourse. Many have likened it to a civil death. As one judge famously said, guardianship, in many cases, is more severe deprivation of liberty than incarceration. But here's the truth. Guardianship doesn't have to mean a total loss of self-determination. We need to imagine a system where protection doesn't come at the cost of personhood. Thus, in 2022, the Administrative Office of the Pennsylvania Courts received a major federal grant from the Administration on Community Living to improve guardianship in 3 ways: improving due process on guardianship proceedings, improving our monitoring of guardians, and promoting alternatives to guardianship. For the past 2.5 years, with support from this grant, the Office of Elder Justice and the courts have launched numerous projects that you will see and hear about during this summit. Our first Pennsylvania Guardianship Summit in September 2023 was one of the projects, as well as a series of videos for families and lay guardians about guardianships, which is available on the website, and soon to be followed by a series of videos for attorneys. There's also been a revision of our web-based resources providing improved information about alternatives to guardianship. There's a highly significant and successful project about which you will hear a lot about during this summit, which is providing legal services attorneys to represent alleged incapacitated individuals in court hearings. There we've created and published a Pennsylvania Guardianship Handbook. There have been enhancements to the guardianship tracking system to improve the ability of the courts to monitor guardians and ensure safety of the people for whom guardians have been appointed. There's been more education for court staff on reviewing guardians' annual reports and monitoring guardianships. And of course, there's been the enactment of Act 61, which I'm sure you've heard a lot about.
The Universal Declaration of Human Rights states that all human beings are born free and equal in dignity and rights. As judges, we recognize that the people and families who appear before us in many different types of proceedings are human beings with a right to dignity, autonomy, and a right to be heard. We understand that guardianship proceedings can sometimes be necessary to protect the well-being of an adult who lacks the capacity to make and express their own decisions. But we also recognize that each individual is entitled to due process of law, and that each individual is entitled to respect as an individual and respect for their dignity. This is so fundamental to what we do every day as judges and lawyers that we may not always take time to consider how essential the right to due process in court proceedings is to the people of Pennsylvania and our nation. As Nelson Mandela said, to deny people their human rights is to challenge their very humanity. Many people working in this room together effectively over a series of years persuaded the Pennsylvania legislature that guardianship can result in so severe a deprivation of an individual's rights and autonomy that it is essential that legal counsel be appointed to represent each individual facing guardianship. One thing that we have learned and will explore through this summit is how important due process is to improving substantive outcomes. By appointing counsel to represent an alleged incapacitated person, by involving more family members in guardianship hearings and allowing them to be heard, by insisting upon thorough and rigorous capacity evaluations by experts, the court is more informed about each individual situation and better able to craft a solution that is specifically and narrowly tailored to meet the needs of the individual and the family before the court. Looking back to when I started as a judge in 2010, the prevailing view then of guardianship was paternalistic and protective. A person who had a disability was viewed as needing protection from the court, and in many cases did not have an attorney and did not have a voice in the court proceedings that were about to dramatically affect their lives. The transformation we have been striving for over the past 10 years is now here. We have placed the person at the center of the process. We value the person as an individual with all of their human rights, legal rights, and dignity. We assure that the person is represented by capable counsel, and we try to grant the minimum appropriate relief that will meet their needs without needlessly depriving them of their rights. As judges, we need to bear in mind that, as the United States Department of Justice describes, guardianship is a double-edged sword. For an older adult who has experienced some form of elder abuse, guardianship can be a critical means to prevent further mistreatment. On the other hand, at times, guardians can abuse their authority by financially exploiting, neglecting, or otherwise mistreating those they've been appointed to serve. That is why it's very important for courts to actively monitor guardians' conduct. Guardians also have a role in preventing elder abuse and should be vigilant for signs of abuse. This summarizes a key challenge for judges who hear guardianship proceedings and for everyone involved in the process. We are called upon to balance the need to protect individuals who are unable to protect themselves with the equally important goal of recognizing the dignity of individuals and not depriving them of their autonomy in areas where they continue to have the ability and desire to make their own decisions. The more I've learned about guardianship in over 15 years, and the more I've interacted with families seeking guardianship or opposed to guardianship, the more I am convinced that our task must be to right-size court orders to the specific and individual circumstances presented in each individual case. By improving due process, promoting alternatives to guardianship, and improving our monitoring of guardians, we can continue to make strides to respect older adults and differently abled adults, to recognize the humanity of every individual who appears before the court, and to provide protective measures when necessary. In these ways, we will work together to continue to improve elder justice in Pennsylvania.
So where do we go from here? We have just shared with you our thoughts and our experiences about our many accomplishments over the past 10 years, and especially over the last 2.5 years. We must remember that guardianship is not just a legal construct. It's a human rights issue. As Eleanor Roosevelt once said, "Where, after all, do universal human rights begin? In small places close to home." So that includes the courtroom, care facilities, the kitchen table, places where decisions are made that shape someone's entire future. Our next steps should be bold, collaborative, and rooted in respect for individual autonomy. So what do we hope you will gain from your participation in this summit? We hope that you will learn from our experiences and bring them back to your communities to build upon our efforts to improve due process and guardianship proceedings. We hope that you will learn about alternatives to guardianship and help others to learn that there may be a solution to their circumstance that is less burdensome than a court-ordered guardianship. We hope that you will learn about Pennsylvania's efforts to improve our information about guardianships and to make data-driven improvements in how the courts respond to guardianships. We hope that you will learn about our guardianship monitoring program to assure that the court-appointed guardians are truly meeting the needs of the individuals for whom they are serving. We hope that you will learn the warning signs of elder abuse and exploitation and work to develop teams in your community that can identify and prevent elder abuse and exploitation. We hope that you will learn about some of the extraordinary people involved in these efforts, such as our governor and legislators, to protective service workers and lawyers across the state who work every day to prevent abuse and exploitation and to connect older adults to resources. We hope you will hear and gain a new respect for guardians many of whom go beyond and above to meet the needs of incapacitated individuals who need our help, and whom they have been appointed to help in the most profound ways. I know that in Philadelphia, through our Elder Justice Committee and Elder Justice and Civil Resource Center under the direction of Susan Chow, and through the excellent presentations of Rebecca May Cole and Dr. Walk from the University of Pennsylvania, we have been providing training for court staff and administrators regarding ageism and bias. We are reframing aging and how society should treat older adults. We are learning how ageism harms our society. We must change the way we talk about aging and change our attitudes, because as we all sit here today, we are all aging in place. So our next steps must be bold, collaborative, and rooted in respect. I challenge each of you to think critically, listen deeply, and act decisively. Reform is not just possible, it is imperative. By improving due process, promoting alternatives to guardianships, and improving our monitoring of guardianships, we can continue to make strides to respect older adults and differently abled adults, to recognize the humanity of every individual who appears before the court, and to provide protective measures when necessary. In these ways, we can continue to improve elder justice in Pennsylvania and to meet our obligation to our fellow Pennsylvanians. As I close, be on alert for preview clips that will be shown during our breaks about our final closing session, Aging in Media, a Closer Look. Please plan to stay until the end of the summit to examine and witness this media presentation of examples of how older adults are projected in the media. We thank you for your attendance here today and the wisdom you will bring to each session, and we look forward to your evaluations of this summit at the end, so we will know how to move forward as we do concerning elder justice. So thank you again for being here, and thank you for your attention. Thank you.
Thank you.
Hello, everybody. There's a lot of you. I'm a little nervous. I'm Amy Whitworth. I'm the director of the Office of Elder Justice, a division of the Administrative Office of Pennsylvania Courts. I want to start today by thanking Judge Murphy and Judge Wood-Skipper for their opening comments, and to just take a moment to acknowledge their leadership, both of the Advisory Council on Elder Justice and also as co-chairs of this fantastic summit. Can you help me do that? It has been a great honor and privilege of my career with the Administrative Office of Pennsylvania Courts to work alongside you on these elder justice issues. And in this moment, I am very full of hope, and I'm excited to continue this work. Our summit theme is transformation, and I invite you now to our first session, Transformations in Pennsylvania, Part 1, Perspectives on Guardianship. So this afternoon, we have collected for you a series of testimonials, each representing a different perspective on guardianship in Pennsylvania. So we begin with Stephanie Bates from Newport, Pennsylvania, which is in Perry County. She's the mother of a 19-year-old son with severe physical and cognitive disabilities. Her son, Trent, is currently served through less restrictive alternatives to guardianship, but Stephanie shares the challenges that she's encountered in navigating his care.
Trent was my first child and had a normal pregnancy. Everything was fine. Normal birth, everything was fine. I thought it was great. Everything was great. But it was quickly realized that it was not fine. Right away, Trent was having feeding issues and so forth like that. But they did say that he passed his tests and they did send him home 2 days later. And so I had this brand new baby, and was just really trying to maintain food in his belly and just settling into this motherhood. And but slowly realizing there were things that weren't quite right, some red flags, and Trent was actually born in October, and it was by Christmas time that we realized, me and my sisters actually realized that Trent wasn't really focusing. He wasn't making eye contact. He wasn't holding his head up. My sisters, who had more experience with babies and children, said, I think by this age he should be doing this, or something's not quite right. So really started to take him to see doctors about everything. As far as my journey as a parent, what really shaped my experience was that pivotal diagnosis eventually that we received after the feeding issue, and then it came to our attention that he had some vision problems, he had some developmental delay, wasn't really meeting milestones with things like holding his head up and such. Hearing the doctor say, your son has an intellectual disability, he has a neurological disorder, he's deaf and blind and will never walk, never talk. It just hit me. All these diagnoses came flying at me, and realizing that we had a really long road ahead. And so just began, really navigating the healthcare system, taking my son everywhere, seeing every specialist, just trying to fix him or, get a cure. This isn't happening to me. And there's just a lot of emotions that come with having a special needs baby. Really is the fear of it. I felt guilty in some way. A lot of guilt came over me, and a lot of sadness and anger, and just very, very stressful times, months and really years of just total stress that is unbelievable. I did along the way get some supports. I found a lot of support through early intervention. I had these wonderful women would come to my house every week, would help me with, feeding and nutrition. Eventually we got vision services, physical therapy. And I just relied on these women, and they really carried me through those times. And then after age 3, he had to go to school, and I had a really positive experience, through all of Trent's schooling. Even today at 19 years old, the schools have always been wonderful. The children that attend school with him are amazing. That was a big fear of mine. I thought that the children might be cruel, or he might have a bad experience, but no, it was the opposite. The kids were great to him. And eventually, through all these years, all of those emotions that I felt have really just turned into acceptance of this, and there is a peace in that. Loving Trent for who he is unconditionally, just really getting a lot of joy out of him, and just really strengthened my character and who I am as a person. It's been hard. Of course, there's been ups and downs, but in the long run, with a lot of support and help from not only these agencies like early intervention, also the patent group, to support me in this, and family and friends. I feel blessed in my life. I wouldn't change anything now when I look back on it. As he is getting older, I am finding that I am getting some stumbling blocks with not having guardianship over him. And at times, healthcare personnel will ask me, can you put Trent on the phone so I can get verbal permission to talk to you? Well, no, he doesn't talk. Or, they want some agency or some entity might want his signature on something, and he can't do that. So, so far, I haven't got a lot of pushback. on the things that I've been taking care of for Trent as far as medical things and financial things like that. But I feel like it's something on the horizon that's coming at me. I intended to pursue guardianship for my son, but I don't know what I'm doing. I didn't know where to go or what to do. So I just contacted my own attorney, who basically hit me with the price tag, and I wasn't able to move forward with that, to be honest with you. I was told a $3,000 retainer, and it wasn't stopping there. And so I had to cut it off, and I just thought I'm going to put that on the back burner until later and deal with it later, because I have a lot to deal with on a daily basis. And so I moved on from that. So for me, initially, it was the money. It's the cost of it. That's a lot of money for me as a single mother. That's a lot of money. It's been a long road, believe me, but I swear I wouldn't change any of it. I love Trent. I love what he teaches me about myself.
And this is why we do what we do. So next, I would like to welcome to the stage Dr. Tawanda Sanders-Williams. She's a nationally certified guardian to discuss co-guardianship and collaboration with families and best practices. Dr. Tawanda Sanders-Williams is the sole proprietor of Cultivation Enrichment and Growth, LLC, a business whose purpose is to support relationships and communities in healing and restoration by achieving sustainable change.
Good afternoon, everyone. I dare you, reimagining guardianship through transformation. When I read the title of today's event, Transformation and Guardianship, a childhood memory came rushing back. After homework, I was allowed to go outside until the street lights came on. And just before it was time to go inside, someone would always yell, "Tawanda, I dare you." Now, if you've ever played I Dare You, you know it wasn't just a game. It was a challenge, a test of character. And for me, it usually involves something related to food, some food that I hated. I dare you, Tawanda, to take a bite of this raw onion. I double dare you. I triple dare you. And as much as I hated it, I'd take the bite, because the dare pushed me past what I thought I could do. And that's what transformation is. It's the adult version of I dare you, a bold invitation to rethink how we care, how we support, and how we advocate for others. And let's go back. In the 1980s, kinship foster care emerged because Black families demanded to be trusted to be caregivers. That was transformation. In the 2000s, Dr. Arthur Evans reshaped Philadelphia's behavioral health system by placing people at the center of care. That was innovation. So what does transformation look like in guardianship today? At Cultivation Enrichment and Growth, LLC, we live the dare every day, and here's how. I propose to hospitals single case financial agreements to create custom discharge plans for those individuals stuck in hospital for non-medical reasons, like two women that I'm currently serving as guardian for. One has been residing on a hospital ICU unit for 2 years because no facility would take her because of complex mental health treatment needs. The second, a young lady, had to have 2 partial amputations of her lower extremities. And after I gave consent, it was discovered that she was in a 2nd trimester pregnancy. And we didn't wait for the system to fix itself. We had to create a pathway out for them both of the hospitals. A woman's sister once refused to serve as guardian because she said she was afraid of the reporting requirements. But through co-guardianship with me, she now visits her sister daily, advocates strongly for her sister, who will soon transition to a less restrictive setting. Our motto at CEG is collaborative, community-rooted, and relationship-based, including those who love them. Currently, we work alongside 27 biological family members across 3 states. 11 now are court-appointed co-guardians along with me. We currently work with a neighbor, 1 Greek Orthodox priest, and 1 church member, all partnering to keep loved ones thriving in their communities and their own homes. We meet with orphan court judges outside of courts to find human-centered paths for complex cases. Our goal is to always collaborate and not just litigate. So what does transformative guardianship mean? It rejects isolation in favor of collaboration. It centers on relationships, cultural relevance, and dignity. It makes co-guardianship a standard of practice and not just a rare exception. It reimagines the guardian's role, not just a manager of care, but as a connector, an advocate, and a partner in possibility. Today, I'm daring you. Transform how you approach guardianship. Take a break from tradition. Lead with boldness, heart, and humanity. I double dare you. I triple dare you. I quadruple dare you. I dare you, I dare you, I dare you. Reimagine guardianship, reclaim dignity, restore possibilities, and say yes to the human experience. And as you leave the summit, ask yourself, what would guardianship look like if I said yes to the dare? Thank you, let's keep talking, and I'm listening.
Thank you, Dr. Tawanda Sanders-Williams. Next to the stage, I'd like to welcome Mary Catherine Scott Esquire from Widener Commonwealth Law to discuss Widener's innovative court visitor volunteer program for law students and pro bono attorneys. Mary Catherine is an associate clinical professor and director of the Central Pennsylvania Law Clinic at Widener Law Commonwealth. In that role, she supervises 2nd and 3rd year law students representing indigent and elderly residents of Dauphin County. Professor Scott is the recipient of the 2021 Central Penn Business Journal Legal Excellence, among many other awards, and she's also a member of our Advisory Council on Elder Justice. So welcome, Mary Catherine.
Thank you, Amy. I'm so very happy today to talk to you about a very revolutionary and transformative program that we have here in Dauphin County. It's called the Dauphin County Pro Bono Monitor Program. This program was started in 2007 by the late Orphans Court Judge Todd Hoover, and he recognized the importance and the duty that we all have in safeguarding the most important population, a vulnerable population, and that would be the alleged incapacitated people. And through this program, he organized an effort where volunteer attorneys could get their pro bono credit and go out into the community and monitor guardians and guardianships and meet with the ward and review financial documents in order to act as the eyes and ears of the court. The volunteer attorneys go into the guardianship proceedings, post adjudication, and write a report to the court, noticing any irregularities, any issues, any potential for abuse, neglect, exploitation. And through that report, the court is able to have a review hearing if necessary to see what exactly is going on. We all recognize the GTS system and how important that has been in the last several years helping with this effort. But having eyes on the guardianship and the guardianships that are assigned to these volunteer attorneys has been instrumental in making change and providing these safeguards for this population. Tomorrow in a session, I'm going to talk about the nuts and bolts of the program, but today I'd like to just give you a war story where this really happened in real time. Last summer, we met with a guardian and a ward for the very first time. It was our first assignment, and the guardianship had been established several years ago where our 60-year-old ward had suffered a brain injury, had had a stroke, and was currently in a rehab facility. And as soon as we got there, we realized that this might not be the textbook case for a guardianship. She first clearly let us know she was fine, she didn't need a guardianship, what can we do to help her? And of course, we let her know that we weren't representing her, we were just, an officer of the court, here to help the court decide what was going on, in her guardianship since she was named a ward after the petition was filed. And so the student and I, wrote a report, it was read by the court, and the court did in fact hold a review hearing. At that point, she had had her two brothers as the named guardians for her, and they were able to come into court. The judge, in fact, it was Judge McNally in this case, was able to meet with our ward, and it was determined that, in fact, a guardianship wasn't needed. We could find some least restrictive alternatives to help this woman and to help her family, support her through this process. In fact, the judge named her one brother as the power of attorney, and she still had some issues that needed to be addressed, and we were able to come together collaboratively to find a situation where somebody could come in, help her with her meds, help her with her groceries, and live a little bit more of an autonomous life. And so this is just one example of where this program, this monitor program, is able to help the court and post-adjudication find out what's going on in the guardianships and make sure there's no issues with these situations. And it's really a program that I'm looking forward to talking to you more about tomorrow, but letting you know that this is something that we hope that you can bring back to your counties and talk a little bit about some of these neat ideas that we've been doing here in Dauphin County. So thank you for your time.
Many thanks, Mary Catherine, for being here with us today. I now wish to welcome Michelle Cluck, Esquire, from Mid-Penn Legal Services Organization to discuss successfully arguing for alternatives to guardianship as a legal services attorney in a collaborative LSO pilot project between the Advisory Council, OEJC, and Mid-Penn Legal Services. Michelle is a staff attorney with Mid-Penn Legal Services, where she practices in the area of guardianship defense for Dauphin and Cumberland counties. So welcome, Michelle.
Thank you. As a guardianship defense attorney, my job is to zealously advocate for my clients' wishes, not to act as guardian litem. Making decisions is what I feel is in their best interest. And believe it or not, sometimes that actually means advocating for a guardianship. Take Betty, for example. I met with her several times. We reviewed the petition, and I explained to her what guardianship was, and she basically had a good understanding. She told me, I want a color, I'm tired, and I want someone else to make the decisions for me. And I understood, because I usually feel that way at 4 p.m. on Fridays. I explored limited guardianship with her, discussing any specific decisions she wanted 100% control over. But she clearly stated she wanted a guardian and could articulate why. And that's exactly what she told the court. In Betty's case, to Judge McNally's surprise, I advocated for guardianship. However, I stayed in the case and visit the client often just to make sure guardianship meets her expectations. Other times I fight hard to avoid guardianship. Bob was in rehab following a surgery. He claimed he was injured during physical therapy and refused to pay for his stay or apply for Medicaid. He owed the facility quite a bit of money. The facility responded by filing for guardianship, essentially using guardianship as a collection tool. Their expert report stated my client was totally incapacitated. This was because he chose not to discuss his finances with an expert in an over-the-phone evaluation. The petitioner went as far as to say Bob could not come to court. It would be too difficult and cause him harm. After an independent evaluation and Bob's in-court, in-person testimony at the guardianship hearing, the judge found he had capacity and the guardianship was denied. In some cases, we find alternatives that protects the client and allows them to keep their autonomy. Doris lacked capacity since birth. After her parents died, her siblings cared for her. One facility refused to share her medical information with the family without a guardianship order. The family had to pay for an attorney, but did not want to be their guardian or have guardianship for Doris. They just wanted to keep doing what they have been doing for the past 50 years. Opposing counsel, the court and I worked together to draft an order enforcing the healthcare representative statute and Social Security representative payee designation, but denying guardianship. We tried less restrictive alternatives. We made sure that an expedited review hearing would be held if any of these less restrictive alternatives did not work, but it's been over a year and there have been no issues. And then there's Danny. Danny's children took him from a home near Texas, drained his bank accounts, and admitted him to a facility in Harrisburg, Pennsylvania. Following a hearing, he was adjudicated totally incapacitated, and a plenary guardian of his person and estate was appointed. But what mattered most to Danny was to see his family, and that's all he could talk about. Danny's brother learned of his whereabouts, contacted the facility, and talked to Danny. Danny's capacity began to improve. There was concerns that he would not be able to fly to his brother's home, but Mid-Pan Legal Services, with the support of Danny's social worker, filed a petition asking his brother be appointed as substitute guardian and allow the client to move closer to his brother. Danny was then adjudicated a partially incapacitated person, no longer totally incapacitated, and he moved to an independent facility near his brother, spent Thanksgiving with his large family. This move was over 1,000 miles away from Harrisburg. And finally, there are times where clients cannot direct litigation, but the petitioner still has to meet their burden. At one hearing on cross-examination, a physician admitted he never met with my client. He signed a report that was completed by a facility administrator. That doctor no longer testifies as an expert. And this is why advocacy matters. Whether it's fighting for a client's autonomy or supporting their desire for help, our role is to listen to the client and make sure they have a voice. Because at the end of the day, guardianship just isn't a legal process, it's a human one. Thank you.
Thank you very much, Michelle. Next to the stage, please help me welcome Bob Lodge, Esquire of Disability Rights PA, to discuss observable changes in practice since the implementation of Act 61. Prior to working with Disability Rights Pennsylvania, Bob worked as an assistant public defender, where he became chief of diversionary and reentry programs, which included mental health treatment court and other specialty courts. His focus during his career has been to represent people with mental health and other disabilities in the legal system. Welcome, Bob Lodge.
Thank you. Thank you. So I've been with Disability Rights over the last 4 years, and when I came there, I was under an ABLE account, an IOLTA ABLE account. I was reading something else there a minute ago. I was able to just represent clients, young adults with disabilities in guardianship cases. And so I was able to meet my clients, discuss with them their interests, their abilities, their goals, and get as much information as I can about them. And that process was a great process, and it was a needed process. And I thought to best represent them, this was needed. And I was then able to meet with opposing counsel, whoever's filing this petition, and we were able to discuss this information and then also discuss these less restrictive alternatives and discuss these other tools that can be used. So by going through this whole process before we even had to be in court, we got to discuss what were the problems, what were the goals, what was needed, and really flush out how we can help best, how the court can help, and we're able to do all of this before we're even in court. And the benefit of that is that gives, I have a better understanding of my client, and it gives my client a voice. I get to speak for them in court, I get to speak for them out of court, and that involvement allows for better outcomes. It involves better understanding of what the court order can and can't do, and how these tools can be used, and whether it ever needs to be changed, whether we don't need a guardianship and someday we may. So this outcome that I've been able to see prior to Act 61, it was fundamental in this whole process. And now with Act 61, that is mandated, that the client in this process has a voice. It creates better outcomes for all parties, and it creates someone that, one, if the client needs to be informed, has a question, it has someone they can then go to. It has the ability to enforce that order if needed, appeals, review hearings. So it empowers this person with a disability, and my focus is typically young adults, and it gives them this voice early in the process, and it doesn't take it away. And I think before this, without having that representation, whether it's intimidation, whether it was a difficult process, it's hard to have that voice in court. Sometimes it's hard for me to get a word in court, and I've been doing this for a long time. So to be able to speak for that person gives that better outcome and pushes for discussion with all parties on what change is needed, what order is needed, if anything is needed. And we have better outcomes in court by having that ability to argue and have that back and forth push and see what's needed for the client. And I think it's a huge step, and it's a huge step in the process. Our view of people with disabilities has changed over the last 50 years, and what someone can do, what someone can't do. I think with Act 61, our law has changed, and I think with doing what we're doing here and with the judges here and with the representation, we're evolving these orders, we're evolving to how someone with a disability is viewed, their voice isn't taken away, and they have that ability to continue doing everything they can do. And by giving them this voice, it allows them not just to be taking something away from them, it allows them to say, this is where I also need support. So it's an interactive conversation now, where before it was saying, well, prove to me you don't need a guardianship. And now it's saying, what can we do to support this person, and what best here, and gives everyone a better understanding of the whole process. So it's been a huge change, and I think as we continue to push in all the different counties throughout the state, that we're making sure this representation is happening, giving people with disability a voice. It's a great change, so thank you.
Thanks very much, Bob. It's now my pleasure to welcome to the stage an esteemed panel of judges and government officials who have compelling testimonials about guardianship to share. So I'm going to call them all up together, and they'll sit wherever they like, in whatever chair they choose. You get to choose. And then I will call on you one at a time and provide a very abbreviated bio, because all of your bios are very long. Okay, so I first want to welcome President Judge Sean Myers from Franklin and Fulton counties, and welcome back to the stage Judge Lois Murphy of Montgomery County. We're also honored to welcome Senator Maria Collette and Secretary of Aging Jason Kovulich to join us. They're moving the chairs. Is that allowed? I didn't authorize that. Okay, all right. They're judges. They can do what they want. Okay, welcome everyone to the stage. We'll begin with P.J. Myers. Since January 2010, the Honorable Sean D. Myers has served as a judge for the Court of Common Pleas in the 39th Judicial District, which is the general court for both Franklin and Fulton counties in Pennsylvania. In December 2019, he began serving as president judge, and he is also the president-elect of the Pennsylvania Conference for State Trial Judges and has served on numerous committees. He's a current member of the Advisory Council on Elder Justice in the Courts. Please welcome President Judge Sean Myers.
Thank you. Is it okay if we sit? Amy, is it okay for us to sit, or would you like us to go to the podium?
I'm not really in charge here, Judge. You may
Okay. Can you all hear me?
You may sit, you may stand, whatever
Great.
floats your boat.
So you'll see a picture projected up there. That's a picture of my mother. Now, you may think I'm instantly going to tell you about a guardianship story that maybe involves her as a subject of guardianship, but that's not the case. The case I'm going to relate is the fact that a petition for guardianship was brought for a woman in my court, and a physician testified with great credibility that the woman lacked capacity. She was totally incapacitated. One of the key diagnoses, though, was mania, and the doctor was adamant that she had no capacity. So I granted plenary guardianship of the person and estate. She had apparently significant assets that her family were not cooperating to try and do a Medicaid application. And I was told sort of this terrible story of her basic need for guardianship service and also a need for preservation of her well-being in a nursing facility of which I knew really doesn't provide very good care. But it's a resource, right? And so, strangely enough, a few months later, her court-appointed counsel brought a petition to revoke the guardianship. And so we scheduled the hearing, and a woman came forward with her court-appointed counsel, who was her longtime friend, who spent half of her year in Florida. But the longtime friend was not able to return to Pennsylvania to spend time with her friend because she was undergoing medical treatment in Florida and couldn't return. And in about a 3-month window, her friend, unfortunately, had fallen out of the principal care of her psychiatrist, and she had been on an emergency placement out of a hospital into this nursing facility, and all of her medications have been absolutely, completely removed. She was left and rendered incapacitated, and the treating physicians of the facility failed to confer with her longtime psychiatrist who had served her for 30 years. She served as the guardianship officer in the South Mountain Restoration Facility until her retirement. Talk about the irony. Thing is, none of that history was ever shared with me, right? And the doctor who declared her incapacitated did so with great clarity and certainty, and he could not be moved off that. The hearing is scheduled. The woman comes in. She walks in and she's asked to take the stand. She takes the stand and she tells me about how she was able to be restored, thanks to her good friend returning from Florida, to her treating physician. She had now had several months of medication. She felt great. She wanted to pick a new place to live. She acknowledged she needed some supportive living, but she certainly didn't need to be in a nursing facility. And then she turned to me quite poignantly, and she looked at me and she said, "Are you Aunt Helen's son?" I said, "Yes." "Are you talking about Helen Myers?" "Yes." "I knew I was coming to see you, Judge. So I went through my old photo albums, and I wanted to bring you this picture of your mother, who I always called Aunt Helen. She was one of the kindest people that I've ever met." And she goes, "I want you to have this picture." So that's what the human connection means to me. And that's why I'm grateful for the amount of review we're doing and challenges we're making to presumptions about the need for permanent guardianship. So I want to thank Robert for facilitating the photograph being shared with all of you. I had just lost my mother 2 years before this hearing. So you may think that of all the photo albums I have of my mother that, I have a lot from the family. That's true. But this is a picture that I keep in my chambers. It's got a lot of important reminders for me before every guardianship hearing. So thank you.
Thank you, Judge Myers. I'll now invite Judge Lois Murphy to discuss a compelling guardianship termination experience about a determined and devoted family. Lois Murphy has been a judge of the Court of Common Pleas in Montgomery County since 2010 and serves as administrative judge of the Orphans Court Division there. She is currently the co-chair of the Advisory Council on Elder Justice and the co-chair of this summit. She works tirelessly. If you think I'm joking, you go ahead and you try to get an appointment or get on Judge Murphy's schedule. I'll wait. Yeah. She works tirelessly on elder justice, so please welcome Judge Lois Murphy.
It's a horse race. Is this working? Oh. Hello? Wait, that's it, right?
Yep.
Okay. Thank you, Amy. It's a horse race, keeping up with our staff. Robert was a little concerned that my story about a family and terminating a guardianship might be similar to Judge Myers, but there are similarities, but there's a difference. In this case, in the Williams family, they came to court in 2016. Mrs. Williams needed a guardian. She had long-term mental health issues that made her unable to care for herself much of the time, and she cycled in and out of mental health commitment, other hospitalizations, and became unhoused. And in 2016, a guardianship petition was brought, and she ended up in a nursing home, which for a time was meeting her needs, at least meeting her basic needs for care, for medical care, for housing and food. However, her symptoms were so significant that she frequently became belligerent with staff, she became disruptive, she became violent at times, and she would frequently end up back in psychiatric hospitalization. Fast forward to 2024, and a lot of good and caring people, including a professional guardian, did their best for her. In 2024, she had another psychiatric hospitalization from the nursing home, after which the nursing home where she had been residing would not take her back. The professional guardian sought out placements and was rejected by at least 25 different nursing homes because of her behavioral issues. And at this point, her sons, she had 3 surviving sons, decided to take her home. They knew the challenges. They knew that she likely will continue to need psychiatric hospitalization from time to time, but they were at a stage of life where they could better meet her needs. And fortunately for us and for her, they were collaborating and committed to her well-being. So one of her sons took her into his home, and her other 2 sons and her grandchildren were involved with her care, involved with her socialization, involved with meeting her needs. And they came into court on a review hearing, and we agreed that they could act as her healthcare representatives as a less restrictive alternative. I appointed 2 of the sons as healthcare representatives under an order, but vacated the guardianship. They no longer needed guardianship of the estate. They only needed a representative payee for Social Security income. And they're meeting her needs with less restrictive alternatives and in a collaborative way. And I just wanted to share that 2 of the sons at the hearing articulated to me how important they feel it is to involve her in decisions, to keep her informed and allow her some agency and dignity. So that was a really heartwarming and challenging guardianship matter, but I wanted to share that experience with you where also we were able to meet her needs in a less restrictive way.
Okay, thank you, Judge Murphy. So I now want to ask Senator Maria Collette to discuss the legislative process with Act 61 and its impacts. Senator Collette represents the 12th Senatorial District. She's a lifelong advocate for working families, having served as Deputy Attorney General in Camden County, New Jersey, as well as a nurse. With the goal of serving her community on an even larger scale, Senator Collette successfully ran for office in 2018, where she's been committed to working for Pennsylvania families. She is a current member of the Advisory Council on Elder Justice. Senator Collette.
Thank you, Amy. Hello? Yep. Whoa. Sorry. Thank you, Amy. And good afternoon, everyone. As you heard, I'm Senator Maria Collette, and I am really proud to represent the 12th District in Montgomery County. As the Democratic Chair of the Senate Aging and Youth Committee, I am also honored to serve on the Advisory Council on Elder Justice in the Courts. I want to thank our Chair, Judge Lois Murphy, from my backyard in Montgomery County, and our Vice Chair, Judge Sheila Wood Skipper, and of course our patron on the Supreme Court, Chief Justice Todd, for organizing our work, the work of our council, and for gathering us all here today as we keep our focus on the best practices for improving guardianship care in Pennsylvania. As you heard, before joining the Senate, I walked two very different professional paths that led me here today. As a Deputy Attorney General handling abuse and neglect cases, I saw the legal complexities of protecting vulnerable individuals. And then, as a nurse in long-term care, I witnessed firsthand the human impact of our guardianship decisions. During my time as a long-term care nurse, I met Janet. That's my mother's name, though this story is not about my mother. Janet fundamentally changed my perspective on guardianship. She was a retired school teacher, 78 years old. She came to our facility for rehab after a fall resulted in a hip fracture. She was sharp, she was joyful when discussing current events and reminiscing about her teaching days, but she often struggled with grappling with medical decisions that she was facing, and she had difficulty ensuring that her bills were being paid on time. Janet's adult son and daughter both lived out of state, and they were deeply concerned for her well-being. They believed that full guardianship was their only option to ensure Janet's safety and proper care. As one of her caregivers, what struck me the most was watching her spirit dim as she realized that she would lose authority and autonomy over even basic daily decisions, where she would live upon discharge, if she would even be discharged from our facility, which activities she would join, what clothes she'd wear, whether she'd be able to access her bank account to add that $5 bill to her grandkids' birthday cards, as she had always done in the past. What her family didn't know, and what too many families still don't know, is that there were then and there are now other options available. Perhaps the limited guardianship focusing solely on medical and financial decisions, or even a supported decision-making agreement that would have preserved her autonomy while ensuring that she still had the assistance that she needed. That's exactly why Act 61's emphasis on exploring less restrictive alternatives is so crucial. Janet's story, multiplied across thousands of Pennsylvania families, shows us why we needed reform and why our continued work matters so deeply. When I stood before you in 2023, we were anticipating the passage of then Senate Bill 506, and today I'm proud to report that bill became Act 61, signed into law by Governor Shapiro in December of 2023. This wasn't just a legislative victory, it was a victory for every Janet in Pennsylvania. Since the law went into effect in June of last year, we've implemented crucial changes. New certification requirements for professional guardians, enhanced safeguards for our most vulnerable Pennsylvanians, clearer pathways to less restrictive alternatives. But perhaps most importantly, we've codified into law what many of you in this room have long advocated for. Guardianship shouldn't be our default option, but rather one tool in a broader toolkit of supports. I see many familiar faces here today, judges who carefully weigh these decisions, attorneys who advocate for their clients' rights, and guardians who dedicate themselves to this crucial work. Your experience and commitment have been invaluable in shaping and implementing these reforms. As we move forward, our focus must remain sharp. With aging adults soon representing 1 in every 3 Pennsylvanians, our work is even more critical and far from over. We must still ensure effective implementation of Act 61. We must continue to expand education about alternatives to guardianship. We must support professional guardians in meeting the new requirements placed upon them, and we must strengthen our monitoring systems. Now, if you've been following anything coming out of Harrisburg or Washington lately, you know that it's quite challenging to get folks to agree on much of anything these days. That's why the unanimous support unanimous support for this legislation received 2 years ago proves that protecting our most vulnerable while preserving their individual liberties and dignities transcends politics. It's about human dignity, it's about justice, and it really is about doing what's right. I'm excited to continue hearing directly from the participants and panelists in this summit, including one of the strongest advocates for improving the quality of life for aging Pennsylvanians in our state government, my friend and Secretary Jason Kovulich. I am eager to learn, like you, about what we can be doing better so that Pennsylvania's Janets and their families have a brighter future, a brighter, more independent, and more dignified future. And I want to close by saying thank you. Thank you for your continued dedication to this crucial work. Thank you for taking time out of your incredibly busy schedules to convene here to discuss how we can build on the success of Act 61 to make the future amazing for aging adults. And thank you for wanting to ensure a more just and effective guardianship system for all Pennsylvanians. Thank you.
Thank you, Senator. So we'll now turn our attention to Pennsylvania's Secretary of Aging, Jason Kovulich, who will discuss the Aging Our Way initiative and more. Secretary Kovulich brings 25 years of experience within the human services field to the mission of serving and advocating for Pennsylvania's older adults. In May 2023, he was unanimously confirmed by the Senate of Pennsylvania to serve as Secretary of Aging. Most recently, Secretary Kovulich has been appointed to not one, but 2 national advisory boards focused on addressing elder issues and promoting healthy aging. Secretary Kovulich.
Thank you. Okay. Nancy, can you hear me? Okay, all right. So Harrisburg Smart, they send me not with 1 but 2 lawyers to make sure that what I say is appropriate and you know, for those of you who don't know me, I'm Secretary of Aging Jason Kovulich, and I'm so pleased to be with you all this afternoon. I want to first take a minute to celebrate Amy and her team at the Office of Elder Justice. If everyone can please give them a hand. This is a tremendous gathering of government officials, of lawyers, of judges, of advocates, of partners, of stakeholders that are focused on elder justice. And I talk about elder justice in a whole different way than I did when I started my path in aging, because elder justice is all-encompassing. And to really tell the story of transformation that I'm here to discuss today, we really need to start at the beginning. And that was the one time I thought I was going to meet with Governor Josh Shapiro and Chief of Staff Dana Fritz, my interview. I thought this was going to be the only time I had to have that opportunity to have that one-on-one conversation with him. And what he asked me is, what do you think the aging network needs? And I said, we need a vision, we need a mission, we need a direction to move in. And shortly thereafter, after I became Secretary of Aging, much to my surprise and to the surprise of many, I believe, we saw that we went to work immediately, long before Senator Collette and her colleagues confirmed me, to build Aging Our Way PA with all of you, with people in this room, with the 52 area agencies on aging. Aging Our Way PA is a multi-sector plan that's nationally recognized, and it's the model for how we're going to move forward as a system, how we're going to promote elder justice, how we're going to change the system for those that we serve for the better. In that year, we saw very quickly a plan develop with over 163 tactics, many of which are focused on elder justice issues. We also saw in Montgomery County, a year after that, the launch of our very first official plan, in which we concentrated on caregivers, which are essential in this space. If we don't have good caregivers, if we don't support good caregivers, then we see other issues arise. We see challenges from burnout. We see challenges from individuals that no longer want to serve in that guardianship type role, and we lose an alternative to guardianship. So in a very short few weeks, at the end of this month, we will be launching the Caregiver Toolkit in Pennsylvania in record time. This toolkit will be the first achievement in Aging Our Way PA that's practical, that's available, that's accessible. It will be launched in Montgomery County, where we immediately launched Aging Our Way PA. It will be available immediately in every part of Pennsylvania, in every language in Pennsylvania, and to everyone in Pennsylvania to support that work. Also in this space, we've reframed the Aging Network. We've worked with the Center for Reframing Aging on a national platform to make sure that we're reframing our work, to make sure that we are talking about older adults in language they want to hear, that we're respecting them, and that we continue to raise the message of dignity for older adults in everything that we do. We did that with our 52 area agencies on aging. We continue to do that with our stakeholders, our partners, and our colleagues to uplift the message of older adults, to change the narrative, and to make sure everyone knows aging in Pennsylvania is important, aging in Pennsylvania is good, and aging in Pennsylvania is the best place to happen, for that to happen. Also, what we've also worked on is reframing senior centers to make sure senior centers are accessible, make sure senior centers are different, that they're not just a place for activities, that they're not just a place for meals, that they're resources for caregivers, they're resources to prevent services from being needed, there are resources to make sure that protective services interventions don't necessarily need to happen because we got out in front of a problem. The only way we're going to stop things like financial exploitation is to educate, to prevent, to make sure that older adults don't fall victim to it. Once that crime happens, it's so hard to get their resources back. So we have worked with all of you, people in this room, to reframe that network too. And as we move forward, we have made sure that we have done our due diligence, as the Senator said, to reform how we monitor the work that we do. We now have a comprehensive monitoring system for the Aging Network, for the work that's done at the area agencies on aging, that's clear, transparent, publicly available, that shows the work that's being done and shows the work that we need to do and make changes to. This is about making supportive change. This is about making sure communities serve older adults the best they can. And we have achieved this under one plan, working with all of you to transform things for older adults that make their lives better, that enhance the services we provide for them. And as we move into the more formal parts of elder justice, when we talk about protective services, and we talk about the work that we've done, we've launched a new chapter, which is the guidance for our 52 area agencies on aging, with specific language about the implementation of Act 61, with directions and support, and how that will evolve in each of our 52 service areas throughout the state. We've concentrated on making sure that there's alternatives to guardianship, that guardianship is not what we reach for first, because there's 24% of the cases in guardianship in Pennsylvania fall back on an area agency on the Area Agency on Aging network. We want to make sure that every alternative is used. We want to make sure that every path is taken before we have to make that step. And we are also working to build an aging program directive to make sure that what we're doing at the department, what we're doing with the 52 area agencies on aging is conflict-free, that we do not have conflict in guardianships, that we make sure that older adults have robust representation in terms of defensive guardianship, to make sure that we have adequately made sure that we've explored all alternatives to guardianship, and that we have quality capacity evaluations before we proceed with guardianship. All of these are the things that we're working with the Office of Elder Justice in the courts, with all the judges here, with all the stakeholders here to make better for those that we serve. We've introduced evidence-based tools in Pennsylvania that are now widely available at area agencies on aging. One being the interview for decisional abilities, which those of you who are fortunate enough to be with us last year heard about. That decision-making tool, that tool that we put in the hands of protective services workers and other workers at area agencies on aging, help us to make a determination if that person has decision-making ability, or that person needs to have a capacity evaluation to formally determine their decision-making ability is compromised. All of this work, all of this change, all of this transformation happened under one plan, Aging Our Way PA, happened because we work with all of you in a very different way. We work with our partners at the Centers for Independent Living. We work with our partners from AARP. We work with our partners at Senior Law and other entities all across the Commonwealth to build a better Pennsylvania for older Pennsylvanians. So I want to thank all of you for being here with us today. I know that was a little bit long, but I want to make sure that you know the path for older Pennsylvanians is going to be a long one, and we are going to continue to work to make sure that we have the best system for older adults in Pennsylvania, that we continue to uplift their message, reframe how we look at getting older in Pennsylvania, and we keep fighting for their rights, their dignity, and their ability to choose to live as they want to, as they need to, as we move forward. Thank you.
I want to thank all of our panelists and all of our presenters. We're now going to take a short break, And then after the break, please return back here for Transformations in Pennsylvania Part 2, updates from the court. That's going to include Judge Wood Skipper leading a panel discussion of fellow judges, plus an update from the OEJC and also from GTS. Thank you.
Can I help you, sir?
You can help me find Maria.
Oh, Maria's gone. We're completely self-checkout now. Much faster, much more efficient. I think you'll like it.
So the price is going to be lower because I'm doing all the work now?
We always have everyday low prices here, sir. Every day.
Every day?
Every day.
Get out of my way. Get out of my way.
No problem.
Whoa.
Please scan your item.
I'm talking to a robot.
Please scan your item.
I just did. See if this thing...
Please scan your item.
You're very boring.
Please scan your item.
Yeah, right.
Sir! Sir! Sir, I need you to stop. Hey! Whoa! Whoa! Hey! Sir, let me help you.
Hit my leg! Get away!
Come on,
Sir, get out of it! I'm a senior citizen! Get out of here!
Why don't you know?
Get out!
Leave that poor man alone!
Whoa!
Your pharmacy stinks!
You motherfucker! That's a damn. Oh, I see y'all want to bring it out. You want to bring it out? Oh, that's all you got. Can I help you, sir?
You can help me find Maria.
Oh, Maria's gone. We're completely self-checkout now. Much faster, much more efficient. I think you'll like it.
So the price is going to be lower because I'm doing all the work now?
We always have everyday low prices here, sir. Every day.
Every day?
Every day.
Get out of my way. Get out of my way.
No problem.
Whoa.
Please scan your item.
I'm talking to a robot.
Please scan your item.
I just did. See if this thing...
Please scan your item.
You're very boring.
Please scan your item.
Yeah, right.
Sir! Sir! Sir, I need you to stop. Hey! Whoa! Whoa! Hey! Sir, let me help you.
Hit my leg! Get away!
Come on, sir!
Get out of it! I'm a senior citizen! Get out of here!
I know what you do!
Get out!
Leave that poor man alone!
Whoa!
Your policy stinks!
You motherfucker! That's a death agent! Oh, I see y'all want to bring it out. You want to bring it out? Oh, okay. That's all you got. Can I help you, sir?
You can help me find Maria.
Oh, Maria's gone. We're completely self-checkout now. Much faster, much more efficient. I think you'll like it.
So the price is going to be lower because I'm doing all the work now?
We always have everyday low prices here, sir. Every day.
Every day?
Every day.
Get out of my way. Get out of my way.
No problem.
Whoa.
Please scan your item.
I'm talking to a robot.
Please scan your item.
I just did. See if this thing...
Please scan your item.
You're very boring.
Please scan your item.
Yeah, right.
Sir! Sir! Sir, I need you to stop. Hey! Whoa! Whoa! Hey! Sir, let me help you.
Hit my leg! Get away!
Come on, sir!
Get out of it! I'm a senior citizen! Get out of here!
How don't you know?
Get out!
Leave that poor man alone!
Whoa!
Your policy stinks!
You mother... Yo! As a veteran! Oh! I see y'all want to bring it out. You want to bring it out? Oh! Hey! That's all you got.
All right, we're going to ask that everyone please come back into the room so we can get started.
Hello?
All right, our next session is Transformations in Pennsylvania Part 2, Updates from the Court. It's my pleasure to introduce to you Judge John McNally, who is a judge in Dauphin County, elected to the bench in 2017. He has served in the Civil Orphans Court and the Family Court Division of his court and presides over guardianship matters. He was selected to participate in the Legal Services Organization pilot project under the grant that was received by the court. You can read full bios from each of these judges in the app, so please do so at your leisure. I'd also like to introduce Judge Dale Faust, who was elected as a judge in Beaver County in 2016. He presides over a criminal docket and orphan court matters and has been the administrative judge for orphan court for the past 5 years. So join me in just welcoming them to this panel. So you have heard quite a bit about Act 61, and part of what this panel is going to discuss today is how judges and courts have been implementing and navigating all the requirements of Act 61. As you know, those requirements include appointment of counsel in all guardianship cases, certification of guardians, professional guardians who have 3 or more wards, review hearings for guardianship hearings, as well as looking for and finding the least restrictive alternative. So we're going to start this off by just asking Judge McNulty, in your county, what have you done or how have you begun to implement Act 61, and what have been some of the challenges in that process?
Well, many of you will recall that almost 2 years ago we were in State College, and this Act 61, it was on the horizon, and it came here quicker than any of us were ready for it, and a lot of us are still playing catch up a little bit. But here in Dauphin County, you heard from Mary Catherine Scott, so we had a really good foundation here in Dauphin County. Like most counties, the judges, the courts appoint counsel on a contract basis. And this was hit and miss in some cases, but now with Act 61, it was required. As you heard, I was invited to by Judge Ott, who I saw walk in here today, to head the pilot program. So we had to get up to speed a little bit quicker than most. But again, we had good bones here in Dauphin County through our guardianship monitoring program with Todd Hoover, who was an orphans court judge's orphans court judge. He was kind of a Yoda, and actually Sean Myers here today is now kind of my modern day Yoda. But we started off looking at Act 61 and saying, okay, how are we going to appoint zealous representation? Because due process, as you heard earlier today, is one of the three major prongs of Act 61. So in Dauphin County, as I'd mentioned, we had people that were on a contract basis. But I was invited to do this pilot program, and that was entered into by an MOU between the county, the Office of Elder Justice in the courts, and Mid-Penn Legal Services. I was promptly told to butt out as far as the interviewing process was concerned, but I was absolutely thrilled that on her own initiative, Michelle Cluck introduced herself to me as a candidate. She joined us, and she has made the program what it is today. Under our rules of professional conduct, the preamble provides that all attorneys are to zealously represent their clients. And I will tell you this, as a judge, the one thing that you must know is justice is not meant to be convenient. Justice is meant to be orderly. So all of you in this room understand your roles in protecting the rights of our alleged incapacitated, our most vulnerable people. Do not ever be afraid that you're not making the judge's job easier. That's not your role. Don't be afraid to piss a judge off every now and then because you are being zealous. But it's important to know the distinction. You can disagree without being disagreeable. And there's a delicate balance there. But the one thing I can tell you, and I'm sure that Dale will agree, the one thing that will gain the ire of a judge more so than pissing them off is not being prepared. We're going through the motions. Before I was doing guardianships, I did children and youth work. And once again, we had court-appointed counsel representing a lot of the parents. Nothing bothered me more than when you turn it over to the parent's attorney and they say, no questions. That doesn't happen in our courts in the capacity matters, because now we have a program where through the legal services model, we have the likes of Michelle Cluck, who is a zealous advocate. And while sometimes she makes me grimace, that grimace quickly goes to a smile because I understand that she is fulfilling her role. Again, not making the judge's job easier, but making the judge work a little bit harder. Because if we all work a little bit harder, because someone like a zealous advocate pushes us, we are going to end up with a better result. We are going to end up with fewer plenary guardianships, more limited guardianships, and sometimes the termination of guardianships. Before Act 61 was implemented and before the legal services model, the only way we terminated guardianships was when the ward died. And I can tell you that since Act 61 has been implemented, since Mid-Penn Legal Services has been providing representation, we have terminated more than a few guardianships. And those are comparable to days that you have an adoption from a judge's perspective.
So, Judge, before you continue with that, we're going to come back to impact of Act 61. I want to turn to Judge Faust. Can you talk about your experience with court-appointed counsel and zealous advocacy, and how that has worked in Beaver County.
Yeah, I'd love to do that. But first I want to mention, whose idea was it to call the theme here transformation? Amy, I'm looking at you. I assume it was you. No. It's a great idea. I want you all to know that you're looking at a trial judge right now, one that's speaking, who has been transformed. There you go. I was, as a practitioner, I know some people here know about this, I was a criminal attorney. I was a prosecutor and a criminal defense attorney. I was a DA, got elected up to the bench, and the president judge in Beaver County had this crazy idea to appoint me an orphans court judge, and I've overseen the orphans court division actually for almost 8 years now. And I've been transformed in this way, starting with lawyers. I have been blessed with about 4 or 5 lawyers who started up with me as an orphans court judge. They were practitioners who agreed to provide representation for alleged incapacitated persons in my courtroom. And I've been blessed. They've been wonderful, zealous. They've worked very hard to understand what it is, what alternatives to guardianship should be. Now, at the end of the last year, I lost 2 of them. I lost one who moved out of the area, one who moved on to something else. And I was in a panic. And I reached out because there is some benefit to being a criminal court judge as well, because I was able to influence a couple young lawyers to come into my orphans courtroom and learn. And the 2 that were leaving helped educate those 2. So I'm back to full staff now. I have 6 relatively young lawyers who are doing a bang-up job. And listen to this. This is a number now. I'm embarrassed by the first number. For my first 5 years on the bench as an orphans court judge, I held 5 or 6 review hearings a year. Since Act 61, over the past year, I'll have you know that this is not a big county, probably an average sized county. I had 5 cases where I terminated the guardianship in exchange for a better alternative for the incapacitated. And I'm telling you, I couldn't have it wouldn't have happened if I didn't have the zealous advocate. It would not have happened. Because don't forget, I'm still worrying about the criminal docket over here, and I got a lot of cases beyond just the guardianship cases. These lawyers came to play, and it made all the difference in the world. And these cases, we're all involved in these things. They're so important, and they can make you feel so good. And that's my comment. I'm transformed. I've been transformed.
So you have a system where you're using a legal services organization. You have lawyers are they contracted lawyers? How?
Not unlike the conflicts attorneys that we have for the criminal cases. No, they're not contracted. I appoint them case by case.
Okay.
Right?
And then they're paid.
And they come out of the county budget. Right. Believe me, it's not a big number. The hourly rate is not great.
So send them to Philadelphia then.
Well, we've talked about this. You wouldn't believe that rate over in Philadelphia. I see a couple of my local lawyers here.
So I'm not going to say what the rate is here, so not to embarrass you. But so Philadelphia sort of adapted a different process, because while we were appointing in some cases, we did not have a court appointment list for orphans court. So we had to create a list of lawyers who could do this work. Because there were not many of them who were doing it, and they were aging and older, we were trying to get some of the less seasoned or younger lawyers involved, because this is something that's going to be a lifetime now. We needed to plan for that. And so we did some trainings and put out an announcement, actually developed a local rule with all the processes and procedures for doing that, and we were able to develop a decent list. We probably could use quite a few more at this point. The thing we are struggling with, and that's why I want to ask you to, is training and education, because we are at the point where some of the lawyers are pretty good, some of them are piss poor, and we are really struggling with making sure they have adequate training and education, and because of our heavy docket, we can't always get it done, and so the onus has become on us as judges to make sure that they are doing that they're actually acting as zealous advocates, that they are reviewing the petitions, challenging information that might be in the petition, particularly because even the petition filers aren't necessarily following all of the rules in terms of putting in their petitions that they have considered least restrictive alternatives and why they don't work. I mean, I just did a hearing last week where it was a Zoom hearing where the petitioner and the family members and counsel for the AIP were all in the same room. So you already know that was going to be a problem, right? It ended up because the family members, it was a case where the individual suffered a traumatic brain injury at 19, and the parents and siblings had been caring for him for 20 years with no problem and no issue. And they decided they needed to have a guardianship. Well, after hearing all of the evidence, yes, the person was incapacitated. He was never going to regain any capacity based on all the expert reports. He can't talk, he's in a wheelchair, he's not mobile. But the parents had been taking care of him. No one had asked them for a guardianship. No one had refused to allow them to make decisions for him. Mom was the rep payee on Social Security. There were no other assets, no pensions, no housing or anything like that. The brother and the sister were also involved in the care. They were meeting with doctors, taking them back and forth to doctor's appointments. And so I found that they were supportive decision makers, they were healthcare representatives, and did an order to that effect and denied the guardianship, although I found them incapacitated. But the lawyer for the AIP asked no questions, agreed that a guardianship was appropriate, and I had to educate him on the Zoom. Have you even read Act 61? Are you familiar with the statute? Have you listened to all the testimony? But any event, those are the kind of struggles that we have.
Yeah.
Give me your input.
So I had the benefit of seeing this side by side because the legal services organization model that we had under the pilot program was only for people that's 60 and older. But we still have a good number of petitions that are filed for 60 and under. And you heard a couple examples of them today. Even Ms. Bates' tale about her son. So I got to see both of them side by side. And I will tell you, we alluded to the hourly rate. The hourly rate is not something that is going to draw a lot of interest. And so you run into a situation where people are taking these sometimes to keep the lights on, but for the younger associate, which is a good place to get their experience, a lot of times they will get pressure from their partners because the hourly rate is not where it should be. So when I got 3 new attorneys that were appointed and awarded contracts, I sat down with them because I knew them. Not one of them had ever done a guardianship before. So we in Dauphin County did a program to train. We gave them PBI books because it ultimately is the court's obligation to appoint counsel through training or experience is qualified. Again, contrast that to the legal services model where at mid-pen you're going to get a Michelle Cluck that this is all that she does. Okay? So the requirement under the Act is she is to meet with the client as soon as practicable and certify that to the court. We've never had a problem because this is what she does. She doesn't have to balance $75 an hour under this versus a client that's going to pay us 125 hours. You don't have that. So the one thing about that, it takes that off the table. So there are plenty of opportunities out there. I know that later this summer, PBI's Elder Law Institute is having something in Harrisburg. I know I'm supposed to speak at it with regard to one of the issues is guardianship. So we will, and it ultimately falls on the court, to provide and make sure that that person is through training or experience qualified.
It does fall on the judge, no question about it. I think if you really want to do this right and do justice to Act 61, you have to make certain that the lawyers who are representing the alleged incapacitated are qualified, experienced, and zealous. And you have to change your calendar. I mean, I just told Judge Wood Skipper this. I've already done 35, now that for her it is not much, but for me, I did 35 review hearings already this year. I told you before, I never did more than 6, like 5 years ago. And that takes time, I suppose money, and of course we're paying those lawyers now. So, yeah, that's my message to the Orphans Court judge. If you want to do it right, you got to put in the time.
So let's move on a little bit. We have a lot to cover in a short period of time. So one of the other requirements under Act 61 is certification of guardianships. Have you experienced an issue or concern about being able to find or have appropriate guardians to fill in for these cases?
Well, I'll tell you that 2 years ago when we were in State College, I think every professional guardian left that seminar feeling like they were the evil empire, that they were misunderstood. I want to let them know that they are appreciated because we all know the work that they do. So there was a lot of consternation over the requirement that the professional guardians be certified. And I have the honor of also serving on the Orphans Court Procedural Rule Committee. So when the law passed, we were playing catch up. We were saying, okay, we've got to get some rules in line that roughly coincided with when the act became effective. I will tell you, I know that Tom Dempsey's here and he served on the committee with me. We did get the proposed rules to the Supreme Court by the time it was implemented. It just took a couple of months for people to massage it. But the one thing that was most debated was that individuals had to be certified. So there's language in the act that says individuals that had 3 or more guardianships had to be certified. Yet the act provides for nonprofit corporations, area agencies on aging can also serve as guardians. So there was a lot of confusion over whether everybody within the organization had to be certified. So for 6 months, I'm sure a lot of you were going out trying to get that coveted national certification. We worked hard to get some clarity, but quite frankly, the committee did not see itself as a super legislator. And so we really read the act rather restrictively that said if they required organizations and everybody within that nonprofit organization to be certified, the legislator would have said that, but that's not what they said. So the rules reflect that. So we've had a lot of people push, and quite frankly, it wasn't such a bad thing for people to become more educated. And I know that there was cost involved, but I feel confident that we have a much more educated and experienced pool of professional guardians now than we did when the act became effective.
I agree with that, and I really haven't had any difficulty with that issue in my county. But I've heard you talk about what you actually do in Philadelphia. I find it fascinating.
So I think part of the struggle in Philadelphia is funding, because there is no funding stream for guardians unless they are in a facility and they get the $300 a month, or if there's money in the estate to pay. And while we have really superb guardians who work very hard for their ward. Oftentimes they're working on a pro bono basis because they're not getting paid, and that we've seen guardians as a result sort of bail out a little bit because you recognize that they have bills to pay, they need food on their table, and the struggle is finding guardians who can do the work with the understanding that sometimes you're going to get paid and sometimes you're not. So one of the things I've been working towards is trying to find some type of private funding source or do a pilot project, and we're in the process now of trying to gather numbers about how many guardians this would impact, how much money are we talking about. Of course, that's hard data to collect because it's not the same in every other case, but it's an issue in Philadelphia. One, probably because of the volume of cases we have, and two, because guardians are bailing out, and three, because we don't appoint guardianship agencies, we appoint individuals, and that may be a problem for some guardians as well. So,
And that is going to ultimately cause a problem because we now have a situation where I know that there are petitioners that are apprehensive to file a petition for a limited guardianship because they know that there's a good possibility that they're not going to be able to find a professional guardian that's going to take that case. So that is something that's coming down the road, and it's going to hit critical mass sometime soon, where we have that problem where, you know, we're pushing for lesser restrictive alternatives and limited guardianships, but a lot of these professional guardians don't want to handle a limited guardianship. So that is going to be something that's going to have to be addressed in the next several years.
so those are things I think we have to keep on our radar. But let's go back to talking about review hearings a little bit, which is also under the statute, which states that a review hearing should be scheduled within the year if there's any thought that capacity will be regained. I know when I first became a judge in orphans court, I started doing review hearings almost immediately. It really was based on my practice in criminal because I started our mental health court and we did review hearings all the time. And so I started doing that right away. And it wasn't as a matter of whether or not they were regaining capacity because I was trying to monitor what was happening with the case. What were their needs? Are they looking for placement? Are they looking for placement? Thank you. And what was really going on, or someone is laying on a church step as their housing, as opposed to agreeing to move into some other location. And so I have always continued to do that. But now that the Act is requiring a hearing in cases where there may be regaining of capacity, how are you addressing that in your review hearings, and what expectations do you have during that review hearing process?
Well, one of the stereotypical situations is where you have someone that is homeless or out on the street, and we heard examples earlier when someone's not on their medication and they get into a facility and within a couple of months they're back on track. When we see that situation, I typically will schedule the review hearing and not wait a year, but schedule it within the next several months. With regard to guardianships of the estate, a lot of times we run into problems with family dynamics when there's a power of attorney, allegations of abuse, taking advantage, scamming people. I will typically, at that guardianship hearing, schedule a review hearing at 120 days because I know that the inventory is going to be filed within 90 days. And if there's anything that will tell you that there's a problem, it should show up a lot of times in that inventory. So we will automatically schedule those. But the other way we typically see review hearings is what Mary Catherine Scott had referred to, is I get the guardian monitor reports, and a lot of times those will trigger a review hearing sua sponte. I had a case that's person lived less than 2 miles from where we're at right now, and I found out that the guardian had died because the monitor could not get contact with them, and the ward was living in the apartment by themselves. That triggered a review hearing. So that's typically where I look first and foremost for the reviews.
I'm happy you mentioned that. This would have been over a year ago, a review hearing as it related to monitoring. A flag came up on a pretty significant estate for an incapacitated person. It just so happened that whenever I do those hearings, when there's flags that come through, they bring up the files to me, and I review them to look at the reports that are submitted. This case was an old case. We're transformed, and I think it's for the best in this Commonwealth.
And I'll just add this in closing. I know that we have found, because we appoint counsel as soon as the petition is filed, and sometimes having counsel there, the counsel has the opportunity to speak with the petitioner, and oftentimes, as a result of that conversation and providing additional information, we have found that petitions have either been withdrawn or they have found least restrictive alternatives, they found family members. So it has made a difference in terms of due process and zealous advocacy. So I encourage everyone just to pay attention to the need for that, and also the training and education, because it is paramount that this is done correctly. So thank you, and I'm going to turn it over to the next session for this. To Amy. Thank you.
Okay, good afternoon again. For this portion of today's events, I'm going to review the grant projects that we've accomplished since our last summit in 2023. See if I can get that to work. Okay, so in review, the AOPC was the recipient of a 3-year, $3 million grant from the Administration on Community Living. The grant period began officially on September 1st, 2022, and will end, sadly, on August 31st of 2025. The grant had 3 overarching goals. For our Elder Justice Innovation Grant, We wanted to assure due process for the alleged incapacitated person under guardianship, improve guardianship monitoring capabilities to prevent abuse and exploitation, and to promote less restrictive alternatives to guardianship. So I'll first do sort of just a quick rundown, a list of all the projects that we tackled under the grant, and then I'll go into a little more detail about a few of them. So of course we had our Pennsylvania Guardianship Justice Summit in September of 2023, and you're all here today for our second Justice Summit, May 2025. After the September 2023 summit, we established regional collaboration groups which met to work on elder justice issues at a regional level. And those groups were somewhat successful in identifying regional problems and coming up with next action steps at a regional level. The AOPC, the OEJC, Office of Elder Justice, we facilitated with those groups to hold public listening sessions, which were very well received. Also, under the grant, we launched the legal service organization pilot project that Judge McNally referred to in his presentation. We'll hear a little bit more about that later. We determined enhancements that should be made to our guardianship tracking system, and we created a guardianship handbook. And we also defined a guardianship monitoring project, which I'm going to discuss. We completed outreach to financial institutions and to medical associations. We completed educational video series for guardians, and we have just recently completed the filming of a second series of educational videos, this one targeted at judges, attorneys, and court staff that'll be launched in 2025. And lastly, we developed resources related to alternatives to guardianship. Okay, so some quick highlights. I first want to talk about the Guardian Handbook. The Guardian Handbook was published in April of 2024, and it's still available in print and digitally in both English and Spanish. It's a comprehensive resource for Pennsylvania guardians, and to date, we have distributed over 8,000 copies of hard copies of that handbook to guardians, the general public who have requested copies, court offices, and public libraries. So next I'll discuss the monitoring project. In Pennsylvania, the responsibility for reviewing the mandated reports that guardians must file, the responsibility of that is on the adjudicating judge and or his or her designee. And it was quite evident in the data that we have available to us through GTS, and also through narratives that we have collected through our interactions with court professionals from all the counties, that some counties have a very strong monitoring process while others are struggling. So the goal of this project was to create a standard of guardianship monitoring and help counties reach that standard. The project had three main goals. First and foremost, to better protect the well-being and asset and security of the incapacitated person, to support the court's ability to properly monitor guardianship cases, and to equip report reviewers to monitor guardianship more effectively through enhanced education and support. The National Center for State Courts published a report review standard protocol, and I was able to work on that committee with the National Center to develop that protocol. So we didn't have to reinvent the wheel. National Center already has a protocol for what does it mean to effectively, meaningfully review a guardianship or conservatorship report. So what we did, our team at the OEJC, is we started with that protocol and we then adapted it for specifically Pennsylvania. In Pennsylvania, we have a huge benefit, which is an award-winning guardianship case management system that is a statewide system that I contend continues to be the flagship of the nation in terms of guardianship case management system. I will wait for your applause. I don't want to talk too much about GTS because I don't want to steal Sonia's thunder, but it is a game changer in Pennsylvania. Whether you like it or not, GTS was a game changer in Pennsylvania. So then after we adapted the protocol, the national protocol specific to our GTS system, we then convened report reviewers from all across the state, and we talked about what is working and what is not working. And from those sessions, we developed a report reviewer training curriculum. We developed and defined specific enhancements that should be made to GTS, and we established a report reviewer listserv to provide community across the report reviewer professionals. From there, we conducted those report reviewer trainings with the goal of getting everybody on board with zealous legal representation for alleged incapacitated people over the age of 60 to discuss and to study what does an LSO project look like. That project was hugely successful, and there was a drastic difference in the number of less restrictive alternatives to guardianship that we were able to find under the LSO model versus those non-pilot counties, and that will be discussed in breakouts throughout the summit. So we also developed an education and outreach program for medical associations, hospitals, nursing homes, and other residential settings, protective services, and for families. We have been everywhere, man. We have gone all over this state to talk about these initiatives, and this was all done with the goal of encouraging alternatives to guardianship, including supported decision-making prior to petition. And these efforts are ongoing, and we're seeing the effect of it. There is a market effect. There is a pattern of almost in a step pattern that you can see the decrease of guardianship petitions coming into the courts across the entire state. We also completed an educational video series. The first series was targeted at guardians. This series was released to the public August 2024 and is still available on the OEJC website. It's available to anyone. The second series is just wrapped filming. Did you see the Hollywood lingo I'm using there, Robert? It just wrapped. We just wrapped filming on that. It was targeted at attorneys, judges, and court professionals, and it is it's in production now, and it will be released sometime in 2025. So we have some pictures here of how Hollywood we went. We actually had like auditions for actors, and there was a professional actors used. There was professional film crew. It was quite impressive. Okay. So also part of the grant, we completed a complete redesign of the OEJC website, and we really enhance the alternatives to guardianship resources that are available there. So this is the website. It's not an easy website, but you can take a picture of it here. Sometimes it's just easier to Google Pennsylvania Office of Elder Justice, and you can find us. But we really would like you to check out these resources that are available there, direct the guardians that you come in contact with to find and also the general public who might have guardianship-related questions, to direct them to this website, because there's really a wealth of information out there that can be very valuable. We also have the OEJC inbox. We take a number of queries from the general public looking for resources into this inbox. If any of you need to reach us, this is a way that you can do that. You can also email any of the OEJ staff directly, and we'd be happy to continue the conversation, collaborate, and continue this work on elder justice. So at this time, I'm going to invite Sonia Waters to this stage to give us an update on GTS. Sonia and I have worked together for 20 years, having started as toddlers with the AOPC. And so this is my friend, Sonia Waters.
Thank you. Well, good afternoon. Amy was joking. She was a toddler. I was a teenager. I'm a little bit older than her. I'm ready to wrap this up. But anyway, good afternoon. My name is Sonia Waters. I'm currently a senior business analyst with the Administrative Office of Pennsylvania Courts. You may hear me refer to our organization as AOPC. And the AOPC is led by the State Court Administrator, Andrea Tueneman. The AOPC's Information Technology Department developed the Guardianship Tracking System, which I'm going to share some updates with you today. And just as a background for those who aren't familiar with the GTS, or Guardianship Tracking System, the statewide implementation of GTS was completed in December of 2018. So as of January 1st, 2019, all 67 counties, which make up Pennsylvania, we're using this Guardianship Tracking System application. And I've had the distinct pleasure and honor of serving in a lead analyst role for the Guardianship Tracking System prior to its inception, and still continue to support the project today. So as Amy's passionate about a number of things, I think I'm just as passionate as she is about this flagship application, as she called it, which it is. So take a few minutes to share some updates with you this afternoon. And it's, again, my pleasure to be here. So if you're not familiar with it, the Guardianship Tracking System is a statewide automated solution for our guardianship cases in Pennsylvania. And I need to use this clicker to go to the next slide. Also, these slides are available in the WOVA app, so you may not need to take any screenshots if you're interested in the information, because they are available within the application as well. Oh, someone put, sorry. So here's the agenda of items I'd like to share with you this afternoon. I'll start by sharing with you some key statewide guardianship statistics, specific, of course, to Pennsylvania. And hopefully this will give you a better insight into the trends that are occurring in the guardianship data, as evidenced by these statistics. And next, I'll provide you with an update on enhancements, some of which are currently in GTS, as well as ones yet to come. And then at the end, we'll wrap up with some training discussions and opportunities for both guardians as well as court users. Statewide statistics. So GTS is a statewide application. All counties must use it. It's an automated solution in that cases are typically electronically filed from a county's case management system into our GTS application. Prior to GTS, we had no way of providing this information to any community. There was no evidence of active cases, amount of money that is being supervised on the cases, and now with GTS, we have a transformation of being able to provide this information to audiences such as yourself. As of this data was as of February 1st, you'll see here on the slide before you, there were 20,530 active cases, of which 19,813 of those having a formal final order of adjudication, and 723 at that point were in a pending status, meaning that they don't have a final order or an adjudication finding recorded on those cases. At that time, there was $2.36 billion under state asset supervision, and that was comprised of 18,704 estate guardianships. That's where we track the amount of funds that are under estate guardianship. Proud to also indicate that we have a percentage rate of about 88% of GTS cases that have been electronically filed. So there's a small majority of ones that are still being filed with the orphans courts via paper, but our e-filing percentage is 88%. And it's been it's grown over the years, but we've been at 88% ballpark figure for the last 2 to 3 years. So here we have judicial automation in effect with GTS. Some other statistics. Heard a lot about Act 61, so I'm not going to try and school you on Act 61, but some things that have changed in GTS as a result of Act 61. One thing I wanted to bring to your attention is the fact that everyone here probably is aware of the incapacitated person representation being required based on the implementation last June of Act 61. To date, of the adjudications that have been recorded from the June timeframe up through February 25th, there were about 1,666, and 80% of those were recorded with information indicating that the incapacitated person was in fact represented. And of those 80%, or those ones that were recorded with IP representation, 76% of those were indicated to be court-appointed representation. And then a much lower figure, which was recorded at the time of final decree, indicate that the appointment was paid by the estate. Again, we're working with OEJC and the courts as well to enhance and increase that number, since it is a mandatory field, to get closer to the 100% compliance of all incapacitated individuals being represented at the time of their hearings. Another statistic I'll share with you is with regard to our guardians who support our incapacitated individuals. In the GTS system, there are 21,005 family lay guardians. That would be a non-professional organization, much what the term family lay means. Professional guardians, as of February 1st, what this data reflects, there were 358 professional guardians, and I just want to give you some background on how we arrive at that number. There are entities or organizations or agencies, and that number of entities or organizations was 223, and then individuals who account for 135 of our professional guardians. I believe it was Judge McNally or someone in one of the presentations who made the distinction of individuals who have more than 3 or more appointments in a non-relative status. So it wouldn't be an individual who's a family member or more than 3 cases is counted towards this 135 number. This is something that, of course, Act 61 has a lot of focus on professional guardians, and we're going to be looking at making some revisions within GTS over time, as well as to how we're looking and tracking certification of our professional guardians. Another set of statistics that might be meaningful, registered guardians. So we currently have guardians who are registered to access what we call the Guardian Dashboard, meaning that they can log in, manage the cases where they're an appointed guardian, and able to submit reports. That number, as of the time this data was collected, was 10,771. And of that, we're now, back in October 2023, we started collecting guardian identifiers with the expectation that down the road there were some future enhancements to GTS that this information would be meaningful for. So what I mean when I say personal identifiers, now a registered guardian must on an annual basis certify details such as their date of birth, social security number, driver's license information. And at this point, we're at about an 81% collection rate when this data was collected. And we'll talk more about what the significance of this data in a few minutes. Next, we'll move on to a few graphs. And again, this information is available in the WOVA app. It may be a little bit difficult to read depending on where you're at in the room, but it's just a chart. We're looking at the number of cases or petitions that were filed. These would be new case filings over the period of 2021 through 2024. Over time, and GTS is still a young application, as well as with changes to legislation over time, we're going to expect to see some trends that may differ from what they were for the first 4 years of GTS. Right now, the data, there's not a whole lot of variance, but what we're expecting is that we may see fewer petitions being filed, or maybe not fewer petitions, but fewer cases actually being adjudicated with an order of incapacity. Active cases, again, we've been looking at active cases over those period of 2021 through 2024. The active cases has not really gone down, and I didn't bring my readers up here, so I can't see these numbers in the small print, but they're pretty consistent. But again, as we track this from year to year over time, the probability and expectation is that there may be fewer active cases as less restrictive alternatives become more of a consideration when determining incapacity for individuals. This chart just is basically stating the number of adjudications that occurred in 2022, 2023, and 2024. In 2022, there were 2,705. In 2023, there were 2,617. In 2024, 22,304. So we are seeing fewer evidence from year to year, fewer adjudications. However, the number of petitions did not go down that much over those period of time. And then lastly of the charts, again, we're looking at how many cases are closed. Closed cases get closed in GTS as a result of a number of factors. Termination of guardianship due to less restrictive alternatives, restoration of capacity, or the death of the incapacitated person. And again, I know when I currently present at the Governance Committee as well as Advisory Council, this is always a topic of interest, just to see what impact we're having with regard to alternative measures as opposed to maintaining a guardianship case. So that's enough for the charts and the figures. Moving on, I didn't realize, here we go. Amy and many others have already talked about the Elder Justice Innovation Grant, but just this has really been a driving factor in allowing us to enhance the GTS application. The grant funds and the initiatives of the grant have spurred many enhancements in GTS that we're quite proud of. Some of the ones that we have implemented or in the process of implementing are listed here before you. Guardian profiles submitted annually are reviewed annually. I talked about that, how on an annual basis, all guardians who are registered to use GTS now have to certify or verify their their attributes on an annual basis. We're also in the process of implementing a criminal background check processing within GTS as well. And then the thing that we're really looking at is being able to compare our GTS participant data to criminal database application data, and I'll talk to you about that in the coming slides. We've also implemented a feed between the PA Disciplinary Board, being able to update attorney statuses and make them more prevalent to court staff based on changes in an attorney status as reflected in their PA Disciplinary Board record information. And then finally, we've added fields or requirements to the GTS application to allow or require the courts to record whether or not an incapacitated person was represented at time of an adjudicatory hearing. I saw Robert holding something, but I couldn't read what it said, so I don't know if it was for me or not. If the building's on fire, let us know, Robert. So, moving on. Oops, I need to hit the right button to move on. Sorry about that. I talked to this, and I'm not going to spend a whole lot of time because I think he's probably telling me I was out of time. I'm not sure. But anyway, part of the 2025 initiative, something that we're working on as we speak, and it'll be an industry-first solution throughout the country, is being able to look at our guardianship data and compare it to our criminal data and inform the courts when there's information that might be relevant in the appointment or the renewal of a guardian based on the information that's matched or obtained from our criminal systems. So when I talk about our criminal systems, I talk about our case management systems that support our court of common pleas, our municipal courts, as well as our magisterial district courts. So if you're familiar with those systems, they're called CPCMS and MDJS, but if you're not, it's just our criminal case processing applications. So what we're looking to do is, based on the types of cases that are listed here before you, determine if any of the qualifiers or identifiers for defendants or respondents on those cases match against any of our active guardians, and if so, inform the courts via an icon associated with that participant record in GTS and provide them with information on what that match details in GTS. So again, we're working on that, and the implementation time frame for this is this summer. It'll be in GTS by the end of the summer. If I have to stay up every day of the week, it will be in place by then. So moving on, just a little bit more background. I told you again how it's going to be matching based on those identifiers that we started collecting and now require on anyone who's registered, or all guardians are required to enter it. However, we're looking at that and comparing it to those same matching identifiers in our criminal applications and providing that information to the courts. Again, it's information only. It's the same information that could be obtained by going to the UJS portal and doing a case search and obtaining this information as well, but we're facilitating providing it readily available to court users with an alert or an icon, as well as making it easy to navigate all of a person's matches without having to do searches across multiple criteria to obtain this information. So pretty excited about this, and looking forward to it being implemented in GTS. Another, I think it might be industry first, but I'm not sure, but it's a leading solution in that we implemented this back in December of '24, in that we now provide information updates to the courts based on an attorney's status with the PA Disciplinary Board. So the Disciplinary Board has always provided us all of our attorney information in GTS, and the status information has always been available in GTS. However, now we're making it more readily available, recognizable, easy to find for the court to say, this attorney now has a status that's no longer active. It could be a status, whether it be a disciplinary action update or no longer able to practice update, but we're providing icons and just making it more aware to the court staff when an attorney's status is changed from an active status to one of these other statuses. It's information. Court staff now receive a notification, as well as the guardian, which some of them don't make sense, because if you're deceased, you're probably not getting that notification, but it is information provided via a notification, as well as an email to the court staff when an attorney's status is changed from an active status to one of these statuses that would trigger this icon update in the application. And those are the statuses that I just talked about that fall under either not able to practice or disciplinary status. The next slide will just show you the implementation in GTS. The red circle down at the bottom has an A in it to indicate that there's an attorney action or an alert where some status is changed on a given record within the GTS. And then here's just a representation of the notification that's sent to the court user as well as the attorney, informing them of this update in GTS. Certifications. Another enhancement that was included in GTS is the notifications for professional guardian certifications. So we have notifications when a certification that's recorded in GTS has expired, is about to expire within 30 days, or when that professional guardian does not have any certification that certification is required. So again, we're keeping the courts as well as the professional guardians informed of the certification status, and with the hope that would prompt the necessary action to ensure that certification is recorded in GTS. Another enhancement that we're planning to implement here before the end of the summer is flag processing updates. Within the GTS application, when guardians submit their reports, there's an interrogation of that data that occurs based upon the submission of the information into GTS that provides the courts with a meaningful report or analysis that says you may want to look into these because it falls outside of a normal range, or something that you may want to be informed of or research further. So we're now going to expand our statuses to make them more granular and provide more meaningful feedback to someone looking at a report to say what action was taken on a system-generated flag and why. Also, we're adding a new indicator to indicate whether an incapacitated person is unhoused. We're adding an unhoused attribute for incapacitated persons so that we can ultimately do reports on that, because we're hearing that it's not uncommon for an incapacitated person to be unhoused, and be able to provide statistics on that as well. And then there's some new GTS reports that would be specific to the court users who would be able to run these reports in GTS. In addition to supporting the court users, the AOPCIT also provides what we call data quality reports, as well as data requests to the Office of Elder Justice in the courts, as well as any entity, but specifically to the Office of Elder Justice in the courts. There are a number of reports that they have ad hoc reporting capability to run on an on-demand basis to identify trends in data, as well as provide outreach to counties to support and say, your pending cases inventory is such, what can we do to help, or are you aware of this, and things like that. So these are reports that the OEJC is specifically interested in being able to keep a pulse on the data as well. Lastly, within the application, there are guardianship worksheets. These guardian worksheets are meant to mirror the data entry of certain actions within GTS, and it will we hope that the worksheets facilitate the entry of accuracy of data in GTS. And these are also available on the Register of Wills and the Clerk of Orphans Court website for access as well. Wrapping up, upcoming training. The AOPC offers monthly online WebEx trainings for our guardians, and they're posted within the GTS application under the bulletin area. And these are some upcoming dates for guardianship training, guardian training for the months of April, May, June, and July. In addition to the online WebEx application or trainings, the AOPC also offers user video tutorials for court staff. So they are 3 to 5 minute tutorials, a total about an hour it would take to watch all 13 of these videos to bring court staff up to date on certain topics. And then in addition to these trainings, we have a trainings team who's also available to provide one-on-one or multiple opportunities for training within your court office as well. Any training updates are again available within the GTS application under the GTS News area. And here's our contact information. Also, I want to put a plug out for the GTS Help Desk. If anyone's ever used the GTS application, you probably come in contact with our help desk. They're available Monday through Friday, 8 to 4:30, and they're a great resource. And if they aren't able to help you, I'll be able to help you. So we all work together on that effort. Finally, I just want to thank you for your time and attention. Again, my name's Sonia Waters, my manager, James McLean. If you have any questions, feel free to see me following this session, and I'd be glad to answer them for you. Thank you again.
I don't know what's happening now. Oh,
Okay, now I know what's happening. I'm pleased to introduce a final video that we have for you today on the perspectives. So I want to introduce Diane Robinson, PhD. Diane is a Principal Court Research Associate for the National Center for State Courts. Since joining the National Center in 2019, her project work has been focused on data governance, collection, quality, and data sharing. Diane has a focus on guardianship and conservatorships and elder justice issues, among other projects. She has led the Guardianship and Technology project, on which I've also had the privilege to serve. Diane's passion and work ethic have inspired me in this work, and I'm pleased to share some pre-recorded comments from her now.
Hi, I'm Diane Robinson. I'm with the National Center for State Courts, where I work in our research and design group. I've had the privilege of working with a number of states on guardianship improvement projects and also working on a couple of national projects about guardianship improvement. So I wanted to talk a little bit about what's happening. One of the common things that you'll be hearing about over the next couple of days is the need for increased data in guardianship monitoring. Pennsylvania has made great strides with this with the guardianship tracking system, and it's something that we see happening in other states as well. The challenge is that in many jurisdictions, some courts don't even know how many guardianships they have open at their local court. And so getting a statewide or national picture can be really challenging. So we're doing some work in that area. One of the things that we have done is in conjunction with our partners at the National Guardianship Network, including the American Bar Association and the National Disability Rights Network, develop technical and business standards for data collection and guardianship. Amy Whitworth has been a really important part of that project, and I'm pleased that we have published those standards. We'll give you a link to those. They have already been adopted by NACM, the National Association for Court Managers, and are currently under consideration by COSCA, the Conference of State Court Administrators. We believe that having those standards will help us to have case management systems that do a better job of collecting and tracking guardianship data, and will provide some clear expectations to vendors about what it is that courts need for these cases where courts have responsibilities long past the time of disposition. So that's one area that we've been pushing hard on and really encouraging states to improve their ability to collect and use guardianship data to do better guardianship monitoring. But we've also seen a lot of work done at the state level in terms of improving guardianship monitoring. A lot of this work has been done through the guardianship improvement grants, and we're really excited to see the progress that's happened. One of the areas is through, again, improved guardianship reporting. Again, Pennsylvania has been a real leader in this with your guardianship tracking system, but more states are building portals that will allow guardians to make reports through more of an interview process, more of a plain language process that will make it more accessible, especially for those family guardians, which we know are the majority of guardians. Not only are states working on those structured interview processes, but also increasingly using software that allows the automatic importation of accounting data from financial institutions, so that people don't have to submit those detailed accounting reports. Not so much detail is required because the court is getting information directly from the financial institution. That, of course, also allows for more consistent monitoring of that, or more quick response if a problem is suspected, rather than just waiting for that annual accounting to come in. So that's something we see happening that is really, really exciting. We've also seen greater attention to guardianship alternatives, and that is really looking for less restrictive alternatives to guardianship and ensuring that we reserve guardianships for those cases in which they are absolutely necessary. This is really important from a civil rights perspective. We shouldn't be taking away people's rights if there are less restrictive alternatives available. It's also a workload issue for courts. We have all courts have limited resources. And we need to make sure that those resources are placed where they're most needed. And so those are reasons both from the individual side, but also from the court side to make sure that we're limiting guardianships just to those people who truly need them. One of the exciting tools that we've seen developed in the last couple of years is Maryland's Ideal Guide. You're going to be hearing more about that during the conference, but it's a guide that was developed and came out of conversations with a lot of healthcare providers and a lot of guardianship partners to really help people who don't work in the court system think through alternatives to guardianship before they come to court with a petition for guardianship. Again, the goal there is to make sure that individuals are only getting guardianships in situations where there is no less restrictive alternative, and that's something that's really important. I've mentioned the need for guardianship monitoring already. A couple of different things that we've seen happening with that. In a couple of states, we've seen more centralized guardianship monitoring. And so sometimes that first blush of guardianship review is being done more on a central level. Minnesota is a state that's been doing this for a good while. Massachusetts also recently moved to doing initial review of well-being reports at their central office. The intention there is to remove some of that work from local courts that may really struggle with it, provide more expertise in that, and again make sure that judges are paying attention to the cases that most need their attention. So that is something that we see happening in a few places. What we see happening even more often is the use of monitoring protocols. I will tell you that a few years ago when I would ask, doing interviews, talking to people working at local courts, and I would ask what they were looking for when they looked at a guardianship report, and the answer was often nothing, or just their own experience. And their own experience can be fabulous, but sometimes when you have turnover, a new person comes in, that's not really enough. And so we've created, again, with the expertise of partners around the country, including from Pennsylvania, guardianship monitoring protocols, both for the well-being report and also for the accounting. And this gives judicial officers or court staff or clerk staff a document to go by to help them identify what they should be looking for in those reports. And those are all available on our website, and you'll be getting a link to that. We strongly encourage the states to take a look at those and then adapt them for your own local needs. So the themes that we really see are the need for improved data collection so that courts can identify those who they should be monitoring, make sure that monitoring is up to date. We've seen improved actual monitoring processes in terms of making it easier for guardians to report, and we've seen a lot of movement towards making sure people are aware and are really pushing for less restrictive alternatives to guardianship. So Pennsylvania has been a great partner in this work, and we really value and admire the work that the Commonwealth of Pennsylvania has done. So appreciate your time today. I'm sorry that I couldn't be with you in person, but appreciate the opportunity to be part of this important meeting.
One of the ways that we keep learning is from collaborating with partners across the nation, partners in other states, and partners like Dr. Robinson. We're learning what other states are doing and keep trying to push that frontier forward so we stay on the cutting edge here in Pennsylvania. I'm privileged and pleased to welcome today two other partners. First, starting with Shannon Butler from Minnesota. Shannon has 20 years of experience as a guardian and conservator, is a current board member of the Center for Guardianship Certification, and an immediate past president of the National Guardian Association, and a certified National Master Guardian. So Shannon, welcome. Thank you for being with us today.
Thank you for having me. Is this working? Can you hear me? Okay. I'm going to wear two hats today. I'm a member, or I should say a board member of the Center for Guardianship Certification, as well as the National Guardianship Association. So I'm going to talk a little bit about both organizations. I appreciated hearing all the information today. I really feel like Pennsylvania is on the right track. In a lot of ways, it sounds like you're really tackling some of the big issues. So appreciate hearing what all you're doing. So as part of CGC, I wanted to welcome you as our 10th state that requires certification through the CGC. Currently, the states that require certification are Alaska, California, which is a hybrid, I will talk about a little bit later, Illinois, Nevada, New Hampshire, New Mexico, North Dakota, Oregon, Pennsylvania, and Utah. There are other states that require some form of certification or training. Just going to briefly touch on some of the ones that kind of stand out to me. The state of Washington, they probably have the most thorough guardianship program in the country, I would say, as far as what they require. They have mandatory 90 hours of training for professional guardians in order to serve in that state. They used to be using the CGC certification as well, but I believe they've developed their own certification process now. Texas kind of does their own thing. They had their own certification. I don't believe that, I'm not sure if they do right now. Sally, do they still require certification, do you know? Texas? No, they're not requiring. They used to have their own, they don't require it anymore. I'm gonna rely on Sally here. She's my guru to go to. North Dakota is a little different. I did a talk with them last year, and what I found interesting about their system is that they have a per diem system for paying for their guardians. So it's a statewide system. Depending on how that client is rated for difficulty or where they're living, they get paid per day based on that client's difficulty, which I thought was very interesting. Illinois, they are all appointed by the governor as public guardians in the state of Illinois. Missouri, they are guardians in Missouri, are elected officials. So that one's a little different as well. I'm just trying to give you kind of a sense of the different things going on out there in the country. Like she said, my whole philosophy is don't reinvent the wheel. Let's learn from other states what they're doing, what states are doing things well, what states could learn from us. Florida has their own certification. They require 40 hours of pre-licensing education. California, like I said, is a hybrid. They partner with CGC, so part of their certification is through CGC, and as well as they have their own state-specific certification that they have to do as well. I'll talk about Minnesota a little bit. There's things at Minnesota, that's where I'm from. Some things we do well, some things not so well. I think we have the My Minnesota Guardian and My Minnesota Conservator, which sounds a lot like your tracking system as far as data collection and tracking guardianships and ensuring the audits of the estates. Some of the things that a couple of things I'm going to point out from Minnesota that I think some of them are similar, but I wanted to just share with you for Pennsylvania. Recently, I believe it was this past fall, we've totally redone our petitioning system for guardianship. It is now a 26-page petition in order to get guardianship. It goes through specifically all alternatives to guardianship, and you have to explain what you have tried, for how long, why it did not work. So we go through power of attorney, healthcare, technology resources, various things. So you have to explain when you do your petition, what have you tried? I think it's a great way. When I have to fill out the petitions myself, I don't enjoy it because it's a lot of work to do that, but it's very thorough, and it really, for judges that don't understand the whole concept of alternative, I think it's a great way to make them pay attention of what else have you tried. We also have a recent law in Minnesota for any guardianship that starts at age 18 or under age 30, it needs to be reviewed thoroughly with a full court hearing every 6 years, so that you can't slap a guardianship on an 18-year-old and that's on there for life. They have to have a full review, which I think is awesome. I've seen so many people, I always say your brain doesn't fully develop till about age 25, 26. There's a lot of them that from age 18 to there, they've gained those skills. And so let's work on getting those skills so they can get off of guardianship. There are several other states currently looking at certification requirements. Indiana, Michigan, Minnesota, Missouri, New York, North Carolina, and Ohio. We are hoping that we'll get more and more states on board with certification. Certification to me is not just taking that test and proving you can answer some questions. It is also the fact that you are saying, I will follow the standards of practice and ethical principles involved with guardianship. And that's what's important, along with the fact that if you are not following those, there is a process that can be gone through with the CGC to get remedies for people that are not following those standards of practice. I'm going to switch over to my NGA hat now. So some of the things with NGA that we've been working on. As president last year, one of my big initiatives was data collection. As you're hearing over and over again, data collection is very important to get a picture of what's going on for funding, reimbursements, all kinds of things. As you spoke to, it was really nice to hear all the data that you're able to pull out of your system. We're trying to work on that on a national level. So what we have come up with so far with the NGA, we do have a data collection committee. This past year, we worked really hard. We realized we were taking on a lot when we tried to say, well, let's collect data for guardianship. That was way too much for us to try to bite off on. What we came up with was we do have a guardianship statement on data collection that's available on our website, saying these are the standards, these are the things you should be collecting for guardianship for all states, and so that we can be comparing apples to apples. Before we didn't have that. We've got various different types of information. We're trying to collect the same information. So that was last year, we completed that statement. That's online on the NGA website. The next part of that is we also wanted to be kind of the holder of guardianship data. So we are also trying to create, be kind of the holder of that guardianship data and update that regularly. So there is going to be like a data collection system in place that we're working on, so that when you're looking for guardianship data on Pennsylvania, you can not only, you can go to Pennsylvania or you can go to NGA. If you're looking for something on Minnesota, you can find Minnesota, those kind of things. So you get better overall picture of what is going on with guardianship. Some of the other things we're working on were, if you're if you're not aware, we have a leadership training we've started this year. So we're hoping to bring up new leaders in the guardianship field. So if anybody's interested in NGA, there's a new leadership training program going on, and that'll be yearly. I see I'm running out of time here. I'm trying to go quick. We also have a new Guardianship 101 training that's in the process of being formed. That's going to be like an 18-hour class, probably online. And, well, I'm trying to go quickly. Oh, I just wanted to say, too, we also have NGA affiliates. Pennsylvania was kind of a unique situation where you didn't have an affiliate organization here in Pennsylvania for guardians. NGA came in and we helped develop a guardianship network for Pennsylvania. So if you're not aware, there is a guardianship network associated with NGA. You do have to be an NGA member to be involved in that, but there is a network that we've helped kind of foster along. My last little plug, and I'll get off the stage, is we're doing a lot of great things. My last thing would be, please advocate for sufficient wages for guardians. I think that that is our next big hurdle. It's not an easy job that we do, and I just feel like we need to be treated as the professionals that we are and adequately reimbursed. Thank you so much.
Thank you very much, Shannon. And finally, I'm really pleased to introduce to you Erica Costello. Erica is the director of the American Bar Association's Commission on Law and Aging. In your materials in HUVA, it says she's the associate director. That's her previous job. She's now the director of the Commission on Law and Aging. For those of you who don't know, the Commission on Law and Aging is a leading resource for information about not only guardianship, but lots of issues that affect older adults across America, particularly in the law, and including advanced planning, really cutting-edge resources and materials that guide a lot of our work. So welcome, Erica.
Hi, Pennsylvania. So good to be here today. Before I begin, I want to just offer you guys a round of applause for everybody here because you guys have done such great work with guardianship reform. I have been really impressed. Every year I do a review of legislation across the country, and every year I see the things that Pennsylvania has been doing, in particular with guardianship reform. It's been highlighted throughout all of the sessions I've seen this afternoon, and especially with less restrictive alternatives. So I just want to let you guys know that you guys are really leading the way in this country. I do oftentimes spotlight Pennsylvania in a lot of the sessions I talk about and the ways that you guys have been moving the needle, in particular with guardianship reform. So again, thank you guys for doing that. I'm just trying to see how I'm, let me see if I can get the clicker, I guess. Yeah, thank you. No problem. Okay, so let's talk a little bit about some of the national trends that we have going on, in particular with guardianship reform. So the things that I'm going to specifically highlight are supported decision-making and the states that have legislated supported decision-making, going over also the National Guardianship Bill of Rights, as well as the Uniform Guardianship, Conservatorship, and Other Protected Proceedings Act, or Protective Arrangements Act. So first of all, I kind of want to start with the supported decision-making. I know that Pennsylvania has really targeted less restrictive alternatives, but really the next step would be codifying supported decision-making in this state. We have now half of the country that has codified supported decision-making either as the concept of supported decision-making and or supported decision-making agreements. This really should be the next thing that you should look at as identifying and targeting here in Pennsylvania. So what are we looking at with supported decision-making? Really, it's looking at making decisions and using individuals or having individuals assisting people in making those decisions, or basically the way that we all make complicated decisions. It's something that you and I do every day. I wouldn't be making complicated decisions without consulting people in my life, whether that be family members, whether that be friends, whether that be other professionals that I'm working with. And so really, again, this is something that we are all doing on an informal basis, but what's really particularly important about the reasons why you want to look at codifying this is really because of that third-party recognition. So we'll be getting to that in a second. Again, I want to kind of highlight some of the things that other states are doing. We have 19 states that have full decision-making agreements, at least in this country. These are just from 2023. I'm actually going to be going through updates this summer from 2023 to currently. And of those states, 6 states use the term principal. It's probably not the best idea because it does get a little bit confusing for people, specifically in the legal practice. It echoes power of attorney language, and when you're trying to make that distinction between a power of attorney document and a supported decision-making agreement, that gets a little bit challenging for people. So again, when you're looking at supported decision-making agreements, you might want to look at other language. Of the 19 states with supported decision-making agreements, only Illinois limits it to adults or persons with intellectual disabilities. So again, very broad coverage. I just came back from an aging conference. We have a lot of work to be doing in that area because supporting decision-making agreements can cover that population as well. So most of the states allow adults with disabilities or simply adults in general to use these agreements to assist them in making, again, their decisions. Again, I go back to the fact that more than half of the country now, and I think we're up to a total of 29 states that now have legislation with respect to supported decision-making in this country as a viable alternative to guardianship. Reporting of abuse. At least 15 states restrict who can be a supporter if there's a history of abuse, neglect, or exploitation, or if there's restraining orders involved. There's also provisions within the statute to terminate agreements if there's a history of abuse by the supporter or if the supporter is abusive in any capacity. And then there's also, in a lot of these legislative provisions, third parties who have to, again, report suspected abuse if there is concerns about abuse, neglect, or exploitation to adult protective services and or law enforcement. So things to consider, again, if you're looking at supported decision-making legislation. Enforcement. Here is again why it's really important to look at codifying supported decision-making. It's for third-party recognition. Why is that important? Because most states permit third parties to rely on those supported decision-making agreements. So it's hospitals, banks, group homes, residential settings, those entities that can now rely on those documents when they're looking at having who's at that table for those care plan meetings, who's going to be involved in those discussions. And it also limits the liability of the third parties who rely on those agreements. Access to information, again, statutes that allow supporters to have access to those information under those agreements, and then most states specifically or explicitly require supporters to keep information confidential. So things, again, to consider with those statutes. All right, now I want to talk a little bit more about some of the things to consider with supported decision-making. I know that, again, we're running short on time. So there's a lot of different individuals who can be involved as supporters. It can include professionals. It can include family members. So we're looking at social workers, case managers, sometimes individuals. It can be attorneys. Attorneys can be supporters. If the person cannot pay, you have to look sometimes through in the community. We're really looking at person-centered planning. These should be, again, for those people who are guardians, this should very much fit within the construct of guardianship, right? Because principles of guardianship, you're looking at person-centered planning and going along with what that person wants. So we're looking at trying to see who could be generating a list to see who can serve as supporters. Oftentimes it could be anybody who's within that individual circle, family, friends, neighbors, trusted professionals, trusted service providers, anybody who they frequently interact with. Think outside the box. Again, when there seems to be nobody, try to look a little bit further. Do they have any regular contact with anybody? Are there anybody that they trust? Distant family members? Sometimes, though, just consider the fact that there may be some negative history and honor their wishes if there isn't a desire to have contact with them. All right, let's talk a little bit about Guardianship Bill of Rights. I see some people here who have been highly involved in this. Fourth National Guardianship Summit in 2021 came up with Guardianship Bill of Rights. It was one of the 22 recommendations that was made. And really, we're looking at several different types of rights, either retained, removed, or delegated. This is really important because it's really codifying rights for individuals under guardianship. And I think some states already do this, but again, we're looking at states to look at their statutes and implementing these laws within their statutes if they don't already have them. Access to justice rights are particularly important when you're looking at right to counsel, right to be present at the hearing, right to have the court know your concerns and complaints about guardianship. So again, these are all things that sometimes states already have codified, but if they haven't, they need to look at whether this is something that they should be looking at putting specifically and explicitly within the statutes. Core human rights. These are things, again, that sometimes states have not really explicitly put within the statutes, but it's something they should look at including if they haven't already. The right to be treated with dignity and respect. The right to be free from financial exploitation, abuse, neglect. The right to remain as independent as they can. Again, these are things to consider if they haven't. And then again, some of the decision-making rights. And so the one thing to consider about the Guardianship Bill of Rights is that, again, we have states that have already kind of looked at codifying this. The most recent one was actually New Mexico. New Mexico just did this within the past month. They did it through judicial rule. So you can look at doing this sometimes through judicial rule, or you can sometimes do this through the legislature. But it's something to look at putting explicitly within your law, so that, again, it's giving rights to respondents pursuant to guardianship, either pre-petition, post-petition. ACOPA. Anybody here has anybody here heard of the Uniform Guardianship Act at all? Yeah, hopefully. Okay, some people. You know, this is, we're on the 4th generation of the Uniform Guardianship Law. And good news, we have now added Kansas to the list this last year, just within the last, earlier this year. It's been adopted in full by Maine, Washington, and like I said, Kansas just added to the list. It was also introduced in Colorado and Idaho this year, and it's adopted in part by at least 5 other states, although several states have already adopted either the 2nd or 3rd generation of it. What's important about the provisions of the Uniform Guardianship Act is that it does have, again, very person-centered guardianship plans and provisions that allow for periodic monitoring and compliance measures, enhanced notice to parties. Many, again, of some of the provisions that you already have looked at in Pennsylvania if you haven't already implemented it. But it also kind of looks at these alternatives to full guardianship, including supported decision-making, and having to look at ways that we can protect individuals under guardianship from isolation from family and friends, as well as making sure that guardians have standards that they have to look up to and expectations as well. So those are just some of the things I wanted to spotlight and highlight. I know we're right at time, so I don't want to keep you because it is your first day, and it's hard sometimes to start presentations on time. But I'll go ahead and turn it back over to Judge Murphy. So thank you so much. Let me know if you have questions.
Thank you, Erica. That was excellent and gave us lots to talk about and think about other things we can do as we move forward. We're at a break. If you haven't already had a chance to check in, this is your opportunity. We will have a networking dinner, so you'll have an opportunity to ask questions of a lot of the people you heard speak today. Dinner begins at 6, and we hope you will join us for dinner, and we hope we'll get a chance to greet you personally and welcome you. And have a good break.